Jess. Then that takes us on to item 3.1, Lord Provost, the investigation reports.
Thank you very much, Gavin. First of all, can I extend a welcome to Suzanne Tanner QC, Julian Diaz-Rainey and Alexander Richardson to today's meeting, and thank you for making the time to come and join us at today's council meeting and assist us with this item. Can I also thank you, Suzanne, for the work that you and your team have done, the exemplary work that you and your team have done in terms of compiling this report and bringing it to us for our attention. For elected members, we have 2 reports on the agenda, both relating to the same upsetting subject matter, that of the appalling abuse perpetrated by the late Sean Bell, and both reports are on the A agenda. The second of these reports is from the Council's Monitoring Officer under Section 5 of the 1989 Act and confirms that maladministration and injustice has been established. We'll be taking these papers together. The first report contains details which individuals, staff and citizens alike may find distressing and concerning to read. It is, however, important that the issues highlighted in the open report are discussed by councillors today. Shortly, I will ask the Chief Executive and Suzanne Tanner QC to make some introductory remarks on the paper, at which point I will then open for members' questions to those 2 individuals. However, before I do so, I want to highlight to all councillors that where possible, I want this debate to remain in the public session. I recognise that there may be some questions which may stray into the confidential territory which may require to be answered. I will, however, do my best to facilitate this, moving to the B agenda for a period if necessary. However, I wish to ask you to consider your questions and comments in this context, and I'm sure that you will share my desire to hold the debate in public in as far away as we possibly can. I will try and hold the bar for moving to the B agenda as high as I possibly can, because I believe that it is in the public interest to have this debate on record, and so that members of the public can either view it online as we speak live or retrospectively from our records. So I will now invite the Chief Executive, Andrew Kerr, to introduce the paper in his name, and also the independent inquiry lead, Suzanne Tanner, to make any comments prior to opening up for questions. Andrew.
Thank you, Lord Provost. I'm going to reserve my comments to the council aspects of this and allow Suzanne to both describe the report and make any comments she would wish to make. Firstly, and maybe most importantly, I want to offer my deepest sympathies to the survivors of Sean Bell, who suffered abuse over so many years, including those that came forward to speak to the independent inquiry and those that may have not felt able to do so. I also want to thank Suzanne Tanner, Julian Diaz-Rainey, who's here today, and Vincent Masons for carrying out the independent investigation in such a sensitive and thorough manner. It has really, as you pointed out, Lord Provost, been exemplary. When it was reported to us in June 2020 that Sean Bell's behaviour needed to be questioned, we immediately set about an internal investigation and suspended Sean Bell, subject to any further inquiry we were to make. We also reported the alleged behaviour to Police Scotland. As soon as Police Scotland advised their criminal investigation into Mr. Bell had ended following his death, I commissioned an independent law firm, Vincent Masons, to carry out an inquiry. And not long after, the council appointed independent chair, Suzanne Tanner QC, who's here today. The report itself lays bare the extent of Sean Bell's abuse and the terrible and long-lasting impact it had and continues to have on their lives. And while it finds that he acted alone and that his actions were not connected to his role, this does not take away from the horrific nature of his actions. Regrettably, it's clear that the evidence gathered by the inquiry that senior officers of the council did not act on extremely serious disclosures by the survivors and others. I want to thank the survivors and the participants for their courage in coming forward to give evidence to the inquiry team. I can only imagine how traumatic that must be for them. It's also right to thank the staff of particularly Children and Families Division, but actually across the council, who are also affected by this, and the disclosures in a public report. On a day-to-day basis, these people protect the citizens of Edinburgh, and I think it should be recognised that for the vast majority of our staff, this is not something that they are used to seeing and were not aware of, and do a fantastic job right across the board. And it's worthwhile acknowledging that they are also affected by this. The report itself acknowledges the efficiency of councillor officers' response after they became aware of the most recent discussions, but I fully appreciate that the survivors will question why this didn't happen much earlier. I agree with that, and for that I apologise on behalf of the council. It should never have happened. There are several recommendations in the report to follow, and the report recommends that we accept all those recommendations in full and anything else the council would wish to consider. It's important we move quickly to build a plan to how we implement these recommendations, and expect to report back to the council in November with those plans. We are going to do everything we can to ensure that this type of incident does not happen ever again. And with that, I hand over to Suzanne Tanner QC. Thank you.
Lord Provost, Chief Executive, ladies and gentlemen, thank you very much for inviting me and Gillian Diaz-Rainey and Alexander Richardson from the team at Pinsent Masons who conducted the investigation into the allegations concerning the conduct of the late Sean Bell and the way in which historical complaints about him were dealt with at the time that they were made. I would like to start by thanking all of you at City of Edinburgh Council for entrusting this important piece of work to me as the independent chair, and to the inquiry team and to the group leaders for supporting and remaining fully engaged in the process throughout. It goes without saying that I also extend my thanks to every member of the inquiry team at Pinsent Masons. Julian Diaz-Rainey was the lead partner from the firm's Manchester office, and he was assisted in his work by Alexander Richardson and Hannah Beaumont, who made up the core team, and other lawyers from the insurance and data protection teams offered their expertise. Each of them brought expertise and diligence to the project, and I thank them very much for the tremendous support that they've offered to me throughout the process. And it has been very much a team effort since we began this process last year. As a team, we have taken our responsibility for this important piece of work very seriously. And from the start, we committed to carrying out a survivor-led inquiry. We have focused wholeheartedly on giving survivors a voice and safeguarding their welfare and that of others vulnerable to abuse. With that in mind, our sincere thanks go to the survivors who have remained the priority throughout our inquiry process. 3 of them have waived their right to anonymity, and we thank them for taking the difficult and important step of contacting the inquiry to share their experiences. They are Emma Barry, Tricia Bell, and Elaine Sampson. But as we have stated in our findings in the report, there is no reason to think that they are the only survivors of Sean Bell's abuse. The inquiry team has been made aware of several other individuals who have suffered some form of abuse at the hands of Sean Bell during the years in which he was employed by your organisation. This includes sexual assault, attempted sexual assault, physical abuse, and verbal abuse. Our thanks go also to the many other witnesses, almost 100, to whom we spoke from within and out with your organisation, who took their time to provide vital information without which the inquiry could not have progressed to its conclusion. We've been extremely lucky to have been able to engage support from a number of other organisations, Line Culture, an organisation specialising in support in relation to sexual violence, provided advice on best practice for interviewing and supporting vulnerable witnesses. The Rape and Sexual Abuse Support Centre in Cheshire, which specialises in assisting survivors of sexual violence, provided specialist support to the survivors in this inquiry before, during and after interviews. And the specialist interviewers from Intersol with extensive experience in the interview of survivors of sexual violence and other vulnerable individuals assisted us with our interviews with the survivors and with witnesses who were considered potentially vulnerable. Thanks go also to your officers and legal team who have engaged with the inquiry from the outset and have fully responded to our requests for both information and documents, as well as assisting with practical arrangements in our dealings with your organisation. And in particular, I would like to extend my thanks to your Chief Executive, Andrew Kerr, Nick Smith, General Counsel, and Craig Russell and Ian Wallace from the legal team. You may recall that when the inquiry team was first instructed last October, and when I became involved in November last year, the scope of the investigation at that time was predicted to involve 10 to 15 witnesses, whereas we've now spoken to almost 100 witnesses, and the first level of the document review produced 600,000 documents which required to be considered. And our thanks go to EY for their work on the initial document review to identify those documents which might be relevant to our inquiry. All of the evidence we've gathered and considered has enabled us to reach our conclusions and to make recommendations which we hope will provide a positive framework for CEC to address many of the identified failings of the past and to ensure that those kind of failures will never recur in your organisation and cause such harm to others. We present the open report to you today, which was included in the papers issued last Friday, the 22nd of October, in advance of this meeting. And the open report is a shorter public version of the full report. Many of you as elected members also took up our invitation to attend at Pint St Mason's offices to view the full closed report. 5 group leaders attended a meeting on Friday the 15th of October to view the full report and to discuss our findings, observations and recommendations. In the weeks commencing the 18th and 25th of October, a further group leader, the Lord Provost, and another 27 councillors viewed the report. So 34 of you in total have viewed the full report. Whether or not you've read the full report, I sincerely hope that you've all had the chance to carefully consider the open report since it was made available last Friday. The only amendment which has been made since then was notified in a letter to each of you yesterday and is a new footnote to be inserted in paragraph 7.1.14 in relation to a point which was outstanding at the time of publication last Friday and has now been addressed. The full report has been similarly amended by insertion of the footnote, and the open report will be amended and made available after this meeting in place of the copies you have. As you have all had the opportunity to consider the open report, it's not my intention today to use up your discussion time by reading through the whole report. However, I thought it might be helpful to highlight a number of points before moving to the recommendations. In accordance with our survivor-led approach, the content of this open report has been specifically tailored to ensure that there is an adequate balance between sharing the experiences of those survivors who wish for their accounts to be shared publicly and ensuring that the wishes of those survivors or contributors who want to remain anonymous or who have not participated in the inquiry are fully respected and honoured. And that is the principal reason that much of the detail from the full report is absent from the open report. Paragraph 3.1.7 outlines our terms of reference. We were instructed by you to understand and establish whether Sean Bell was involved in abuse of any kind and or inappropriate behaviour, and if he was, the extent of any abuse and whether anyone else from the CEC was involved. The extent to which any abuse established to have occurred was connected to Sean Bell's work as a social worker or his employment with the CEC. Whether any other CEC employees, current or former, had any knowledge or suspicions of any acts of abuse by Sean Bell. Whether any steps were taken or not taken by the CEC or its employees to respond to any past allegations or suspicions of abuse by Sean Bell. The reasons for any identified failures to address any past allegations or suspicions of abuse by Sean Bell, and whether Sean Bell misused public funds, and if he did, whether any employees, current or former, of CEC had any knowledge or suspicions of the misuse of public funds. In relation to the final point on the misuse of public funds, during the course of our inquiry, having reviewed certain documents relating to the allegation, we recommended to the CEC that this allegation be dealt with by way of a separate investigation to be commenced, if required, following the completion of the inquiry. That was because, given the wealth of information the inquiry team received in relation to the principal issue, that is to say, Sean Bell's abuse, the inquiry team did not want to delay publication of its findings and recommendations in this regard, given that the inquiry team had, by that stage, spoken to several survivors of such abuse. Any delay to proceedings would have likely had a significant emotional impact upon the survivors of Sean Bell's abuse, of which you're aware there are several. The inquiry team await a decision in this respect, but the open report does not contain any review of or findings in relation to the suggestion that Sean Bell misused public funds or that certain employees of the CEC had knowledge or suspicion of such misuse. The focus of the findings in the open report is therefore concerned with the sexual and physical abuse perpetrated by the late Sean Bell on others, the knowledge or suspicion of that abuse by those within CEC, and the actions or failures to take action by those within CEC in response to such knowledge. Those who have read the full report will be aware that it focuses on and is structured around 5 formal disclosures to CEC from the 1990s until 2020 in relation to abuse perpetrated by the late Sean Bell in relation to a number of survivors. Those 5 formal disclosures and our conclusions in relation to them are summarised in the open report. However, it is worth highlighting that the 5 formal disclosures do not comprise the entirety of the times that certain CEC employees were told of serious acts of impropriety on the part of Sean Bell. Indeed, over the years in which Sean Bell was employed by the CEC, several members of CEC staff were told of various reprehensible acts that Sean Bell had allegedly committed, from sexual and physical assault to domestic abuse and coercive control. You will find our conclusions in relation to the questions posed in the terms of reference at section 7, which begins at page 18. In relation to question 1, was Sean Bell involved in abuse or inappropriate behaviour? The answer is yes. We are satisfied on the evidence that Sean Bell was a serial abuser. That abuse took many forms. For some, it was simply verbal, but for others, it was both physical and sexual abuse. We accepted the evidence which showed that at least 3 witnesses were repeatedly sexually assaulted by Sean Bell, and there is no reason to suspect that those individuals are the only survivors of such abuse. Paragraph 7.1.2 outlines the detail in respect of the formal disclosures of Emma Barry and Tricia Bell. And it is our view that Sean Bell seriously assaulted a fellow colleague in the 2010s. We also obtained evidence of an alarmingly similar incident to this assault by Sean Bell against his ex-wife Elaine Sampson, which had occurred many years earlier than the assault on the fellow colleague. Question 2. Was anyone else from the CEC involved? The answer is in 7.1.4 that we found no evidence to suggest that anyone else at the CEC was involved in Sean Bell's abuse or inappropriate behaviour. Question 3. Was the abuse connected to Sean Bell's work as a social worker or his employment with the CEC? The answer is in 7.1.5. In respect of Sean Bell's abuse of those who are the subject of the alleged formal disclosures, that is to say, Emma Barry, Tricia Bell and another individual, the inquiry team has found no evidence to suggest that such abuse was connected to Sean Bell's work as a social worker. However, there is evidence, which was accepted by us, that Sean Bell's actions in exploiting his position at the CEC to attempt to discredit Emma Barry and in his dealings with other CEC employees involved with Emma Barry at the time were closely connected to his employment with the CEC. Additionally, in respect of Tricia Bell and the other individual, given that both of them worked at the CEC at the time when the abuse occurred, there is a clear proximity to Sean Bell's employment at the organisation. Question. Did any other CEC employees have any knowledge or suspicions of any abuse? Answer, yes, several. Paragraph 7.1.6 outlines our findings in this regard. In respect of the knowledge or suspicion, there are 3 delineated camps. There is knowledge or suspicion that is derived from a formal disclosure having taken place. There is knowledge or suspicion that is derived from an informal disclosure having taken place. And there is knowledge or suspicion that is derived from rumour, gossip and speculation. Our views on who at CEC had knowledge of each of the alleged formal disclosures and our conclusions in respect of the CEC's liability in this regard are set out at paragraphs 7.1.12 to 7.1.21 in the open report. Question. Were any steps taken or not taken by the CEC and its employees to respond to any past allegations or suspicions of abuse by Sean Bell? And what are the reasons for any identified failures? The answer to that is dealt with separately for each of the 5 formal disclosures. The first alleged formal disclosure. In the 1990s, a CEC employee was made aware of inappropriate behaviour towards Emma Barry on the part of Sean Bell. The failure to properly report, escalate and investigate the allegations of inappropriate behaviour was a significant failing of the CEC. The second alleged formal disclosure. Sean Bell seriously assaulted a fellow colleague in the 2010s. That incident was reported by the survivor to their line manager, who in turn reported it to Andy Jeffries, who was then Senior Manager of Children's Social Work Services at the CEC. He subsequently informed Alistair Gaw, then Head of Support to Children and Young People at the CEC. And a dossier was widely disseminated at the CEC, which included details of the incident. The CEC did not take appropriate action. Such action should have included the launching of an investigation in conjunction with a report to the police. Given the highly sensitive nature of the work carried out within the communities and families, formerly the Children and Families Department, and the position of utmost trust held by Sean Bell, it is completely unacceptable that such appropriate action was not taken. The CEC policies in existence at the time, although perhaps not comprehensive, were sufficient enough to have mandated the CEC to escalate the matter further and to report it to the police. It is our view that the failure to take appropriate action was a failing of the CEC and was in breach of CEC's own policies that were in force at the time. In respect of the individuals involved in the decision to take no further action, namely Andy Jeffries and Alistair Gough, it was a dereliction of duty on their part, compounded by the fact that as vastly experienced social workers themselves, they really should have known better. Indeed, they should have been considering the risks posed by Sean Bell to both his alleged victims, as well as other CEC employees and service users. The third alleged formal disclosure. Sean Bell abused Tricia Bell physically, sexually and psychologically over a prolonged period of time. During a private meeting with Andy Jeffries, Tricia Bell alluded to the fact that she had suffered some form of abuse by Sean Bell. Notwithstanding this, an appropriate investigation, which would likely have resulted in a report being made to the police, was not commenced. Tricia Bell's account supported that of the individual that is the subject of the second formal disclosure. It was corroborative evidence. The failure to take appropriate action was a failing of the CEC and was in breach of the CEC's own policies that were in force at the time. The fourth alleged formal disclosure. While Emma Barry disclosed past instances of abuse and inappropriate behaviour to a CEC employee in the 2010s, those disclosures were made in general terms in respect of the nature of the abuse and the extent to which it had occurred at the hands of her stepfather, Sean. Further, those disclosures were not attributed explicitly to Sean Bell. At the time of this disclosure, the recipient of that information did not know who Sean was or that he was a social worker at the CEC. Therefore, no direct criticism is levelled at the CEC in respect of the fourth alleged formal disclosure. The fifth alleged formal disclosure. In June 2020, Emma Barry disclosed to a CEC employee details of the abuse she, her mother and another individual had suffered at the hands of Sean Bell. The matter was then escalated up the management structure at the CEC and referred to the police. The police subsequently arrested Sean Bell, who later took his own life prior to the commencement of any criminal trial. In relation to that disclosure, the CEC acted appropriately and followed the necessary policies. The CEC launched its own investigation, reported the matter to the police, considered the potential risk to Emma Barry and suspended Sean Bell all expeditiously, which is what we would expect from your organisation. The only area upon which the CEC could have improved was in respect of its communications with Emma Barry at the time, to ensure that she was fully aware of the appropriate steps the organisation was taking. Following our conclusions, we've included an observations section at section 8, and we've outlined a number of observations based on the evidence obtained in the inquiry, which, while not strictly falling within the parameters of the terms of reference, may be of assistance to you in understanding how situations arose in which Sean Bell was allowed to continue with his inappropriate conduct over many years without any appropriate action being taken until 2020. I turn now to the recommendations which are contained in section 8. We were asked to consider whether further changes in policy or practice are needed to prevent any recurrence of the allegations concerning Sean Bell, and to report to you on the above matters and make recommendations. Our recommendations are based on the work we have undertaken in relation to the inquiry, and it is our sincere hope that they will be considered by the CEC for implementation in full, subject, of course, to the considerations which are outlined in the report. We hope that in considering the recommendations, you focus on the interests of the survivors, both those who contributed to the inquiry and others who, for their own good reasons, may have felt that they were unable to do so. We are aware that letters of apology have already been sent by Andrew Kerr to Emma Barry, Tricia Bell and Elaine Sampson. Our recommendations are grouped under a number of headings. There are 5 recommendations in relation to investigations, and we are recommending reform of the processes for investigations relating to sexual allegations, domestic abuse, physical violence, stalking or harassment, to ensure that the processes are independent and impartial and are seen as such both within and out with the CEC. We're recommending the implementation of an independent investigation unit of appropriately experienced and properly trained investigators. We're recommending that all such allegations must be escalated to the CEC's monitoring officer prior to the appointment of any investigator, and that a record should be kept of all such allegations for an appropriate period of time to allow for identification of patterns of behaviour. There are also recommendations if you decide that the system of investigation for such matters should remain internal, and those relate to training, specifically around issues involving conflict of interest, and to ensure that investigators properly conduct interviews with alleged survivors of various kinds of abuse and make necessary referrals to support services for those survivors. We also recommend that the CEC should look at an external service provider with appropriate expertise to design and deliver the training to CEC employees and to provide refresher training. That then follows to the recommendations in respect of training and education, and there are 3 recommendations under that heading. And we recommend that employees within communities and families and the wider CEC receive appropriate training and education to ensure an effective safeguarding culture for both employees and service users. We also make recommendations in relation to training for employees with line manager responsibilities in relation to domestic abuse, coercive control, and how to appropriately deal with those individuals making complaints of a potentially criminal nature. And again, there is a focus on record keeping. We also recommend that all employees of the council with line management responsibilities should be required to undertake mandatory training on public interest disclosures, the 2019 whistleblowing policy, and to enable them to differentiate between those kinds of disclosures and matters falling under other CEC policies. There are 3 recommendations on policies and procedures. The current HR practices in CEC relating to relationships between CEC employees are inadequate and do not reflect the close working and personal relationships between many CEC employees, which are often undisclosed. And we therefore recommend that a policy should be created which stipulates that relationships between CE staff members must be disclosed if they involve an individual with line management responsibilities, and include the steps to be taken if a situation involving allegations of a sexual nature, domestic abuse, or those relating to physical violence, harassment, or stalking, whether within or out with the working day or CEC workplace, arises between employees who are or were involved in a relationship. And finally, in relation to policies, we recommend that the 2019 policy on domestic abuse should be revised to state explicitly that it covers situations with CEC employees which arise outside the workplace and or outside work hours. There are 5 general recommendations. The first is that there must be a formal system in place at the CEC for recording disclosures by employees, service users, or others relating to such allegations. That record keeping must be improved within the CEC, with notes taken at all meetings where disclosures or concerns are raised by employees to line managers regarding allegations of this nature. And once recorded, line managers should be obliged to report such disclosures or concerns up the management structure at CEC. And we also recommend that a record of all investigations conducted regarding abuse of a sexual or physical nature, harassment or stalking should be kept by the CEC for a period of 25 years in a searchable and accessible format, subject of course to GDPR considerations. It is our recommendation that an appropriate CEC redress scheme should be set up without admission of liability to compensate those who have been abused by Sean Bell. And the final recommendation is that familial or former familial relationships of employees within the CEC should be disclosed and logged appropriately on both employees' HR files to ensure that any actual or potential conflicts which may arise during the course of internal investigations are addressed. Those comprise our recommendations, and I hope that I have adequately summarised the main features of the open report. I'm very happy to take any questions on the open report, as is Julian Diaz-Rainey, the lead partner from the inquiry team at Pint St Masons, and I thank you for your time and careful attention as I presented the report today.
Thank you very much, Suzanne, for that very in-depth and clear description of the inquiry's work, its findings and very clear recommendations. I thank you for that. I'm now going to open it up to questions, and just to remind members that the questions are either to Suzanne Tanner QC, to Julian Diaz-Rainey, or the Chief Executive Andrew Kerr only. And if you can indicate in the chat box as normal, I will call you in order. And first I have is Council Leader Adam McVeigh, please.
Thank you very much, Lord Provost, and thank you to Suzanne and her team for the diligent work and taking us through the information in the report. I've two questions, one for Suzanne around her experience of cooperation within the organisation, and just to give her thoughts on what level of cooperation there was from the organisation. Did she find that helpful and engaging and open, or anything else? I would invite her to comment on that. Also, probably more of a question for the Chief Executive, but happy if Suzanne or anyone else on the team wants to comment on it as well, around the level of support. We're quite conscious with the level of policies that people can experience a number of abuses within their own personal lives, or as a result of people who are working within the council. Just comment on the level of support that's available within the organisation for survivors who find themselves in that position, regardless of how they find themselves in that position.
Well, perhaps I can answer the first question that Mr McVeigh's posed in relation to cooperation in the organisation. As I think I indicated in my opening remarks, we found that the organisation was fully cooperative throughout. All the inquiries that we passed to the organisation were diligently dealt with. Craig Russell and Ian Wallace were our main point of contact on a day-to-day or weekly basis in terms of inquiries that we had. We had a number of extensive document reviews, and Ian Wallace worked tirelessly to put together the information that was requested in those document reviews and provide that to the inquiry team at an early stage to allow the document review exercise to be undertaken. And the council also assisted us to reach out to those people who'd left the organisation prior to the inquiry. The only rider to all of that is obviously in our inquiry we had no power to compel any witnesses to take part. It was an entirely voluntary process, but there isn't anyone that we felt that we required to speak to who, for example, refused to participate in the inquiry within the organisation.
To answer the second part of Councillor McVeigh's question, there was regular communication which went to all employees, if I take the generality first, to make sure that anyone who was affected by this issue, because of course it's been very public in the papers, offering help and counselling should that be what they wish if they're affected by these issues. We have done exactly the same to the survivors, the known survivors of this issue, and it's my intention that we have offered an individual conversation with each of the named survivors after this consideration today, where that issue will be dealt with should they wish to have continuing support as they go forward. So it's a fairly comprehensive offer, some of which has been taken up by those directly involved, but actually some who have just been affected by the thought of the abuse that was undertaken and the fact it was undertaken with colleagues in their department, etc. So that's what we've done.
Thank you. Councillor White.
Thank you, Lord Provost. This is an extremely concerning report, and Ms Tanner has outlined a series of events which to me speak of a number of missed opportunities to solve the problem. I mean, I think one of the things for me in looking at that is that we must thank, as well as the survivors and those who came forward, the social worker who accepted formal disclosure 5 in 2020, and their management, the police and the Crown Office, who acted to address something in weeks which had been ignored for years. So thinking about missed opportunities and noting the contents of paragraph 5.2.2, which highlights some of Sean Bell's serious criminal abuse of women, the decision that some of these cases fell out with the remit of the inquiry. Why have several of these individuals' complaints been ruled out when the terms of reference at paragraph 3.1.7 say the inquiry team was instructed by the CEC to understand and establish A, whether Sean Bell was involved in abuse of any kind and or inappropriate behaviour, and if he was, the extent of any abuse, and whether anyone else from CEC was involved. So that suggests a wider set of abuse. I ask why those weren't taken into account, and I have two other things to bring back on that, Lord Provost, but I'd like to hear Ms Tanner's view about that first.
Well, thank you very much, Mr White. We didn't rule out the other forms of abuse, and they are, as you say, mentioned in the full report. In relation to some instances of abuse that have previously occurred, there was very limited information, and the findings and reflections in the report and on the basis of that information have been included in the full report. And those include, for example, a physical assault on another employee within the workplace. But that took place quite some time ago. There was very limited information about it, and the person involved in being abused by Sean Bell in that situation had decided at the time to take no further appropriate action. So it's mentioned because it's important in terms of identifying patterns of behaviour, but we decided that the focus of the report should be on the serious abuse perpetrated by Sean Bell, which was formally disclosed to the Council on a number of occasions.
Thank you, Lord Provost. That's helpful to understand how the inquiry looked at this. I suppose my issue is that several other individuals came forward with issues. Over what timescale did these events take place in relation to the 5 formal disclosures? And specifically for me, given that formal disclosures 2 and 3 in the early 2010s were to senior members of management in the Council, do you believe these incidents could have been prevented had action been taken on disclosures 1, 2 or 3, which were about criminal offences? And were any of these, the survivors of these incidents, linked somehow to the Council? Because you've been very clear about people who are clients or staff, but I wonder whether there were any other links to people who came forward in the public, private or voluntary sectors, or otherwise at all related to Sean Bell's extended work relationships.
I appreciate the Lord Provost's comments at the outset about wanting to keep as much of this debate public as possible, but I can't possibly answer that question in detail without considering the individual pieces of evidence and whether they were contributed by those who wish to remain entirely anonymous or those who were happy to provide their evidence on an open basis.
Okay, on that basis, we'll hold that question over, Councillor White, because I'd like to keep the A agenda discussion going, but we'll come back to that at the end and see what we wish to do.
I'm content with that, Lord Provost. I think I was looking for a general indication rather than details of individual cases and whether there were opportunities missed. But I'm happy if we have to do that separately, then we have to.
Thank you, Councillor White. Councillor Rose.
Thanks, Lord Provost. Thank you, Ms Tanner, for your report and for leading a very difficult inquiry. Ms Tanner, having seen some of the submissions and conclusions of the so-called misuse of public funds issues in 2011-2012, I'm coming from a position where I think a detailed and thorough review of those allegations and their conclusions is essential. Now, you've already made reference to your comments, or the report's comments. The inquiry team recommended to Edinburgh Council that this allegation, which was the misuse of public funds and whether other employees had knowledge or suspicions, recommended that it be dealt with by way of a separate investigation to be commenced, if required, following the completion of the inquiry. And I note that you made reference to that, and it's footnote 1 on page 8. The covering report from the Chief Executive, on the other hand, says, and this is paragraph 4.6 of that report, that the inquiry team is of the view that this particular matter has already been addressed and investigated to a conclusion. How do I reconcile those two statements?
So I obviously did not write the comment in the Chief Executive's report, but if I can explain further, that the allegations concerning misuse of funds, which encompassed allegations of payments being made in which Sean Bell may have been involved, and also in relation to recruitment malpractice, were raised in 2011. Those were actually, they form part of the same dossier relating to allegations involving a survivor. Those allegations were investigated under the public interest disclosure policy in place at the time in the council. So an internal investigation was conducted in your organisation at the time into those allegations. Then reference was made to the monitoring officer in your organisation as to whether or not these were monitoring officer issues, because the internal investigations had found that neither of the complaints were upheld. And the monitoring officer sought legal advice from an independent legal firm who provided advice which my inquiry team has had sight of, and that law firm reviewed how the internal investigations had been conducted, whether there was a reasoned basis for the findings reached in the internal investigation, and whether they were properly matters to be in front of the reporting officer. And for those reasons, the inquiry team recommended that if there was to be a further investigation into these matters, it should occur after we had progressed the matters in relation to Sean Bell's abuse. It's a fairly substantial exercise, and it would certainly be substantial looking back at allegations relating to alleged misuse of funds 10 years ago. It would involve the consideration of a large number of payments made from within this respective department at the time. And the inquiry team's position is that it may not be proportionate to conduct that investigation at the expense of the public purse, but it's entirely a matter for you as the City of Edinburgh Council to decide whether to do that investigation. And we simply suggested that in terms of timing, we should progress the abuse allegations first. And as far as I'm concerned, no final instructions being given to the team about whether that still has to be investigated.
You're muted, Councillor Rose.
Sorry. Thank you for that response. Indeed, it may not be proportionate and it may well be expensive. But if I can just put myself and yourself in the position of those who made the public interest disclosure, who launched grievances at that time to bring these things to attention, subsequently were absolutely crushed by the responses to those investigations, or of those investigations, How do you regard how they will feel now if they were to be told that there was to be no further inquiry of events or inquiries which may have been tainted, may be regarded as a cover-up, or may not have adequately been investigated? And I reflect in these words the comments that have been made to me by survivors. Do you have a view on the balance of the need for further inquiry?
Clearly, you will want to take into account the interests and needs of the people to whom you refer, who raised the allegations, which were raised alongside fair treatment at work complaints that were made at the time. And the complaints were split into fair treatment at work and public interest disclosure matters. And clearly they will have a view about the outcomes, and no doubt they were unhappy with the outcomes at the time and may continue to be unhappy at the outcomes at the time. But your suggestion that the investigations may have been tainted is not something that's contained in any documents that my inquiry team has seen. But as I say, we have not looked into these matters, and you have to make the decision, and you have to balance the interests, and you have to decide whether you want to investigate these matters for a third time.
Thank you. Lord Provost, may I put a related question to the Chief Executive in relation to that?
One last question, Cameron Rose. Yep.
Yep, thank you. Mr. Kerr, there appears to be a discrepancy between what's in your report about what the inquiry says and what Ms Tanner has just said.
No, well, if it is, it's unintended, because as Ms Tanner just outlined, that's exactly my understanding of the situation, and the report recommends the action on the basis that it has already had an internal inquiry, external legal advice, considerable documentation review, and therefore it is set aside. But we did agree with the inquiry that the important thing here was the investigation of the Sean Bell part, and that if there was required to be any further investigation on the financial report, that that shouldn't be the priority of the inquiry, as described by Councillor.
But my point is that your report says that these inquiries have been reviewed and addressed and investigated to a conclusion. Yeah, that's not what Ms Tanner said.
That's the Council's position, Councillor Rose.
Okay,
they were
I'm going to move on, because we're actually diverting away from the main purpose of this meeting. I think it's been quite clear that if Council wishes to progress this at a later date, it's within our remit to make a decision so to do. So I'm going to call on Councillor Day.
Thank you, Lord Provost, and can I echo your comments and thank Suzanne, Julian, Alex and Hannah and other members of the team who've helped a fully independent investigation. I have three very brief questions, Lord Provost. My first question is probably to Ms Tanner. In the report it mentions about the boys network. Could you expand a little bit on this statement and advise the Council what is the current status of any networks that were identified? My second question is following from Councillor McVeigh's question about cooperation of the Council. What was your experience of elected members' engagement, and were there any issues with that process? And my final question is probably to Ms Tanner and the Chief Executive. The SSC were advised of Sean Bell's cases of abuse some time ago, but seem not to have acted. Do you have any views on their failings or what we can do next regarding that? Thank you, Lord Provost.
Well, thank you, Mr Day. In relation to the first point you raise, I think it's a reference to the material at 8.1.4c, where we record that it was suggested by a number of witnesses that Sean Bell was believed because he formed part of what is described by witnesses as an old boys network, which was individuals within his department who, above all else, looked after their own. I have to preface my remarks by saying that clearly the purpose of this inquiry, the Apple inquiry, was not to look into the Council as a whole and the remarks are restricted to comments that were made about the boys' network within Children's and Families that was seen to protect Sean Bell. And we have noted our understanding that the actors who have been identified by witnesses as being part of that network in that department are no longer employed by the council. The evidence, in summary, was that a number of men who had started at the council at around the same time and progressed through the ranks of the council looked out for, protected one another, and in the case of Andy Jeffries, had a blind spot towards any conduct perpetrated by Sean Bell or reported to him. And I understand that those within the council might be interested in names being provided, and there would be no issue whatsoever out with this public meeting, with a discussion taking place to provide those names so that other matters can be looked into, such as other investigations that were carried out by members of people who were seen to be in that boys' network. I hope that answers your first question, Mr. Day.
Okay.
I think question 3 was also addressed to me, which was in relation to the SSC. I think you said that they took no action, but in fact the SSC, we understand, commenced an investigation which seems to have lasted a period of some 2 years into the allegations that were contained in the 2011 dossier. So that included the allegations which we have called the second formal disclosure in relation to the unnamed complainer in the 2010s. And it also included the allegations of misuse of public funds. And the SSC conducted an investigation, and at the end of that investigation decided that they were not going to take any further action against Sean Bell, which I think that probably more appropriately describes the fact that an investigation did take place. However, my inquiry team did not look behind a SSC investigation. We don't know to whom they spoke. We don't know whether they also requested or were provided with 600,000 documents. We do not know the extent of their inquiries. We do not know if they spoke to 100 people, and we don't know which survivors they spoke to. So I can't answer any other questions, and your inquiry would probably be best placed with the SSC.
My second question was directed at you, sorry, Suzanne, was about following Councillor McVeigh's question about cooperation. What was your experience of elected members' engagement and any issues with that process in terms of questioning your colleagues?
Overall, elected members' engagement was a very positive experience, but I want to be entirely honest that there were some difficulties in the engagement with elected members in the process. Some of those may seem fairly minor, and they wouldn't amount to any kind of interference in our work as such, but there were complaints around, for example, the timing of 15 sessions over which you were invited to come in and view the report at Pinsent Mason's offices, and those complaints were clearly personal to councillors rather than thinking about the interests of survivors or the overall process of the inquiry, because they involved such things as recess, half-term holidays, etc. What I can say is we accommodated every single councillor who said that they wanted to come and read the report. We put on extra sessions, we offered evening sessions, we ran sessions into the following week. We accommodated everybody. Perhaps the requests could have been put to my team in a different way, if I can put it like that. During the reading sessions, there was excessive questioning from some councillors. Again, I don't take it to be interference. It was a very distressing report for people to read. It took a number of hours. There were a lot of questions, some of which as lawyers we might not find to be relevant, but which of course to you as politicians may be highly relevant. I hope that I and the team did our best to answer all of the questions that were put to us. Again, some of them might have been put in a different way or with a different tone. But that's entirely a matter for you and how you conduct yourselves as professionals. And there was only one councillor who I believe, although I was not present, crossed the line of what I would consider acceptable behaviour in a professional context. And I mean that with respect to any professional context in terms of shouting at a junior female member of the inquiry team, and a letter is being sent about that separately. So I hope that answers your question, Mr. Day.
Thank you.
Yep, thank you very much. Andrew, do you have anything to say on that?
Just for completeness, I absolutely agree with Suzanne on the history, the history of SSC involvement. They have also been kept entirely informed about the progress of this report, and I would expect them to further consider any actions taken as a result of this external investigation. It would be normal for them to wait till the external investigation has been publicly reported before deciding on any further action at this moment in time. They have also been kept completely up to date with our actions against any individuals or with any individuals named in the report, and again, I would expect that they would consider what action they would require to take after the conclusion of this external investigation.
Thank you, Andrew. Thank you, Councillor Day. Councillor Johnson.
Thank you, Lord Provost, and thank you, Ms Tanner, for your report. The period of time that this report spans is from the 1990s, I think, until 2020. Why didn't you feel the need to interview any of the chief executives that were in place at that time?
There was no suggestion by either Mr. Jeffries or Mr. Gaw that they had escalated the matter anywhere beyond Mr. Gaw. So there was no suggestion that anybody else at a higher level than them had even been made aware, for example, of the second and third disclosures that were made. And none of the witnesses in the other teams to whom disclosures were made suggested that anything had been escalated to a higher level. The only chief executive to whom we spoke or reached out to in relation to one point was Dame Sue Bruce, who was asked about the point which is now reflected in the report in the footnote, which contains her position in relation to whether or not she had cited the dossier in 2011. And it was felt appropriate to clarify that matter with Dame Bruce because there was witness evidence that suggested that the dossier was circulated widely to senior individuals in the organisation, including the chief executive. But Dame Bruce's position is quite categorical that she's never had sight of the document prior to it being provided to her by the inquiry team.
Given that the criticism that you level at Mr. Gaw and Mr. Jeffries, would it not have been worth confirming with them and the chief executives above them if that was the case? You seem to have taken Mr. Gaw and Mr. Jeffries at their word.
Taking them at their word in relation to which point?
It was never passed further up the chain of command.
Well, that was the evidence that the inquiry team accepted from them and from other individuals, that it was never passed further up the chain of command, and that is my criticism is levelled at them.
If I could return back to Councillor Day's questions about the Old Boys Network, as you describe it in the report, just to confirm, it's your understanding that was it 7 members of that network?
There was no discussion about a number of people being part of the network.
Okay.
And it's not contained in the full report.
Okay. Is it your understanding that all of these people no longer work for the council?
I think I've already answered that question by saying that we're happy to share the witness evidence on that point if it enables the council to move forward and ensure that none of the people are still in the organisation. And you used the word organisation, in fact, and what I prefaced my remarks with earlier was that the boys network we were concerned with in the inquiry was the one within the CF department, which we were told about, and not anything within the wider organisation. And it is a point which my review into the council's whistleblowing and organisational culture is looking at and will be reflected in the review report, which is issues about network and gender issues more widely.
Thank you.
Thank you, Councillor Johnson. Councillor Munro.
Yeah, thank you, Ms Tanner, for the report. One of the things that surprises me about the report is there's no reference within the documentation there is in terms of personnel procedures in that with regards to the groundbreaking work that was undertaken by the city with the zero tolerance campaign, because I feel that work should have led to heightened awareness by all concerned, and whether that should be part of the report process as well. Is it because the city led on that particular initiative that everybody involved should have been more aware of reporting? And then secondly, you mentioned the further report and further work there. Is the team willing to accept further contributions for that further review, given what will happen post the council decision today, which may give individuals the confidence to come forward with their own personal experience and evidence? And I realise that you said that review might be next month in November, but if people do decide to come forward, would that be welcomed by you and your team?
Okay, thank you, Mr. Munro. There was, you're correct to say that there's no reference to the zero tolerance campaign in the report, but I hope that it's reflected in the comments that we have made, that the social workers involved in the report should, through their own professional experience and training and knowledge of that campaign and others, have been well aware of the issues. And in fact, it was raised in witness interviews with more than one witness about developments going on generally in social work and people's understanding around issues such as coercive control. Those issues should have been at the forefront of the minds of people working in this area with vulnerable service users. So while it's not reflected by name in the report, that is very much part of the landscape within which the individuals were working. On the second point in relation to the review, that although the short answer would be that the call for evidence is closed and that we've analysed the evidence and we're in the final stages, we have been accepting late submissions from contributors to the review if they meet the exceptional circumstances test and fall within the terms of the review. The difference between the review and the inquiry, of course, is that the review is thematic and we're not looking into the merits of individual cases, but people's individual experiences may, of course, inform us. And so if anybody to whom you speak, or in fact who's watching the broadcast, feels there's something that should be brought to our attention and we're able to take that into account before we publish that final report, then we will attempt to do so, and we will at least respond to any such individual to tell them what decision's been taken.
Thank you. Councillor Laidlaw.
Thank you, Lord Provost, and thank you, Ms Tanner and team, for the report, and also for the flexibility in allowing so many different slots for people to come in and view the report. I think it is slightly disappointing that the numbers that did read the full report. My question relates to how many CEC employees who worked with Sean Bell were invited to participate in the inquiry. I assume all, and how many of them refused. I understand this is not a judicial inquiry, so there's no compulsion, but whether or not perhaps that is due to perhaps a sort of culture of fear of reporting and escalation within that department, and if that's something that was raised by those that did cooperate with the inquiry.
I note your comment in relation to the numbers of councillors who viewed the full report, but obviously that's entirely a matter for the councillors concerned. In relation to the council employees who participated in the inquiry, almost all employees we contacted participated in the inquiry. There were some people who refused to give evidence to the inquiry. And as you say, we had no power to compel witnesses to give evidence to the inquiry. And we were also hampered by the fact that some employees had left the employment of the council. And while, of course, we made efforts to both locate and reach out to them and invite them to participate, we were not able to compel anybody to participate. I would say that we received a very large number of witnesses in response to our call for evidence, which was published last December. That was widely advertised, both from within the council and out with in media and on social media, and people did respond to us in relation to that. There was also a system an informal system whereby people who were involved in the inquiry spoke to former colleagues or friends who might have had something to add. They then contacted my team and spoke to the inquiry. So I hope we reached as many people as possible, but we were never in a position to compel those who refused to cooperate with the inquiry.
Okay. Thank you very much. Councillor McClellan.
Thanks very much, Lord Provost. Thanks very much again to Ms Tanner and the team at Vincent Masons for such a thorough job in producing what's obviously a very harrowing report. My question is that in relation to 7.1.5 in the open report to Ms Tanner, it is the extent to which you would agree that Mr Bell's actions were not connected to his role, and further in the full report, I think I can mention this without divulging or compromising any confidentiality, that his predatory behaviour in the department was so extensive that it also included students visiting the department. So again, would it be the case that you can say that his actions were not connected to that role?
So I think, Mr McClellan, on a careful reading of 7.1.5, we've restricted the answer to those who were the individuals subject to the alleged formal disclosures, which would be Emma Barry, Tricia Bell, and the individual concerned with disclosure 2. So for those 3 individuals and their disclosures, we said that it was not connected to his role, other than the close connection with Tricia Bell and another individual who worked in the organisation at the time, and the way in which Sean Bell operated in trying to discredit Emma Barry in his dealings with others and speaking to social workers within the department. So it very much does not extend to the other matters to which you refer, which may indeed be very connected to Sean Bell's role. And one of his particular roles when he was working in the organisation was as a liaison with university students.
Thank you very much. So it's also the full report also documents the extent to which colleagues were involved in helping people who were victims and people who were targets of Mr Bell's actions. So that in itself would have had, by any stretch of the imagination, a disruptive effect on the department as a whole. So again, is it fair to say that his actions, and that could be as broadly defined as you want it to be, that his actions were not connected to his role?
I think, to be entirely clear, the actions that are being referred to here is whether his abuse was connected to his role. But so I fully accept that there would be repercussions in having to deal with complaints coming into the department or any other issues concerning Sean Bell's behaviour in the workplace. But the question that was being answered there was whether the abuse was connected to his work as a social worker or his employment with the CEC. And I don't want that to sound overly legalistic, but that is the question that we were answering. But I fully take the point, and we have expressed in the full report, which you've seen, Mr McClellan, that there were other instances where matters were reported to CEC in relation to Sean Bell.
Thank you.
Thank you very much.
Thank you. You have another question, Councillor McClellan?
Sorry, Lord Provost. Yeah. In the chat, but I did say I'd like to put the question to the Chief Executive as well. Straightforwardly, Mr Kerr, can you say that, as you've stated this morning and in your earlier statement to the press, in very broad terms, that Sean Bell's actions were not connected to his role? When the report would suggest, and what Ms Tanner has just said, would suggest that in the broad context of what we've read, and the broader definition of actions, that in fact his actions were very much connected to his role, counter to what you said?
So I think I give the same answer as in 7.15. The abuse was clearly not connected to his role, and occurred outside. In other words, was not dependent on his status or it, but the other actions within the council, which is in the full report, may well have had an effect on being enabled by his role in the current in his current life, just like any senior person would be in any organisation.
So you would accept then that his actions, in the broadest sense, were connected to his role?
I would accept that it's possible that some of the actions outside the abuse may have been connected to his role.
Okay, thank you. Councillor Watt.
Thank you, Lord Provost. And for what it's worth, might note that I am the first woman to actually ask a question. Firstly, can I thank Suzanne Tanner and all her team for the kindness and consideration that was shown to me when I attended to read the report, and the proper consideration that was given to the points that I raised with yourself prior to the reading. It was very much appreciated. I did mention to your team that I would have a couple of questions. Regarding the recommendation that employees' personal relationships be disclosed to HR and held on their file, I have two concerns. I fear that this might deter women from disclosing abuse if they have not previously disclosed a relationship that they are having with someone in the council. Secondly, in my experience, too often this disclosure policy results in women being discriminated against in terms of scrutiny, being moved from their role, generally being treated with suspicion, and being denied promotion or being excluded from workplace opportunities because of these disclosures. How can we as a council make sure that discrimination and deterrence of reporting of this nature does not become an unattended consequence of this very otherwise very sensible recommendation?
Well, thank you, Ms. Watt, and thank you for your comments about the reading of the report and our communications before you attended at the offices. You're most welcome. In relation to disclosure of personal relationships, the recommendation has not been made lightly, but in an organisation such as yours, which is a huge organisation within the city and within Scotland, if you think about the number of employees, there are bound to be relationships. And given the issues which have occurred that have given rise to our investigation, we made the recommendation on the basis that we feel on balance that these matters should be reflected and held on record, because some of these issues would not have been the missed opportunities. The relationship between Emma Barry and Tricia Bell and Sean Bell, for example, would have been noted on personnel files, and matters might have been caught at an earlier stage when the individual to whom Emma Barry spoke was not aware that Sean Bell was her stepfather. So I do take on board your concerns that this might deter women from disclosing abuse, and I hope that it would not do so. I can say that obviously our review into the council's whistleblowing and organisational cultures, looking at how barriers to all kinds of disclosures might be addressed in the organisation, because there are real and perceived barriers to people reporting wrongdoing in the organisation. And I suppose this is one aspect of it, that it might unfairly discriminate against females within the organisation. I think that's a matter that probably needs to be worked through operationally. and perhaps with input from yourselves as councillors. I don't know how much further I can offer on that at this stage.
Thank you. Your answer is very much appreciated, and hopefully cognizance will be given to this by the council going forward. Thank you.
Thank you, Councillor Watt. And just for the record, I call councillors in the direct order that they indicate in the chat bar that they wish to ask a question. Councillor Dickey.
Thanks, Lord Provost, and thank you to Suzanne and her team. I just want to say that I'm deeply thankful for your work and I know that's been carried out, so thank you so much. The report speaks about, the survivors that you're already aware of out there, and there may be other survivors to come. And we've just spoke with John McClellan's question about the link to the Sean Bell's post. But the council cover report says about you have not identified any misuse and mistreatment of children in this particular inquiry. So although it's not linked to his work, I'm also conscious that Sean Bell was responsible for some of the most vulnerable women and children, in the city. And I suppose, and I'm not sure how you can answer or what you can answer, Suzanne, but my question really is, in the course of the inquiry, did anyone come to you with concerns about children? And how confident can we be that those survivors that are yet to come forward or we're aware of are not children? I hope that makes sense.
Well, thank you, Ms Dickey, and I can confirm that there was no evidence brought to the inquiry concerning service users, either adults or children. So there was no evidence of that nature, or it would have formed part of the inquiry report. But as you yourself have recognised, there may well be other survivors, and there have certainly been suggestions to the inquiry team that there are other survivors, and I would expect that if the redress scheme is set up by the council to deal with survivors who have been subjected to abuse by Sean Bell, then you may find that other survivors do come forward at that time, even if they did not feel able to contribute to the work of the inquiry.
Okay, thank you. Councillor Arthur.
Thank you, Lord Provost, and thank you, Ms Tanner, for your work and the work of your team. I'm sure others agree with me when I say I was really disappointed to hear that one of the councillors acted unprofessionally in your offices. I hope your letter generates a prompt apology. In terms of my question, it relates to the so-called old boys network. Later in the agenda, we'll be discussing whether or not the complaints that they dealt with should be investigated to see if they've been dealt with properly. Based on your experience of the Sean Bell and your inquiry, what confidence do you have that the paperwork and the data around these people will be as full as it should be?
I can say in all honesty that I don't have a great amount of confidence that you would have paperwork of the appropriate amount relating to particularly historical complaints. The note-taking around the issues we were investigating was very, it wasn't good at all, in fact non-existent in some circumstances, and that involved us even going to the extent of checking PA's diaries, people's diaries to see if meetings had been noted. There were no records of important meetings which had taken place. There were no minutes taken of meetings. There were no proper notes taken of disclosures. So I wouldn't be entirely confident that you would find the material that you require, even in relation to matters which were investigated. And that's one of the reasons that one of our strong recommendations is that there's a much more thorough system of investigations with proper documentary evidence of investigations that are undertaken.
Okay, thank you. I mean, that's very concerning, particularly given some of the cases that these people would have been dealing with day to day. But it leads me, it's a good transition into my question for Mr. Kerr, and that's that it's when Ms Turner read out her recommendations earlier, I thought it was shameful that it's taken these events to generate some of these recommendations. Some of them are common sense, like the one that's just outlined. So are we out of step here with other councils Are these recommendations things that we should have been doing, Mr. Kerr? Are these changes long overdue? And is there a risk that other people have been let down because we don't have these processes in place properly?
It's quite difficult to answer, Councillor Arthur, because I would say yes to some of what, and agree with you in some instances where it's very obvious that we need to improve, and we haven't recognised that the record keeping and note taking, etc., that Suzanne's just outlined, for instance, has been inadequate. Other things are difficult to make any comparison with. And some things are not, because other councils do and other councils don't. And there's a whole mixture of practice, because of course, in the conversation we've been having with the inquiry, we've already started to look at what will we need to do to make these recommendations happen, and what is a reasonable benchmark against other organisations of our size. So we've already started to do that process in anticipation that we would be implementing a number of these recommendations. So undoubtedly, our record keeping and our ability to have comprehensive HR records, particularly historically, has hampered a number of our investigations over the past. And Suzanne's right about having to do an awful lot of what I would describe as digging for information when it should have been more easily available, and we will have to address that going forward.
But hindsight's a powerful thing, and I'm applying that to myself rather than your comment, to be honest, Mr. Kerr. But if a number of investigations have highlighted this deficiency, including quite a high-profile one we've recently dealt with in full council, why weren't these changes made already?
Without referring back to the different investigations, Councillor Arthur, I can't actually answer that in the thing, but I am happy that when we go forward to the recommendations that are going to be made by Council, that we give you a briefing about exactly what we're doing, what we have done, and why we haven't undertaken it till now.
Okay, thank you.
Thank you, Councillor Arthur. Suzanne, I'm conscious that you've been sitting there answering questions for an hour and a half now, very diligently and comprehensively. I still have a number of elected members who wish to ask questions. Would you prefer to have a small 10-minute break at this point in time rather than pushing on?
I don't mind at all, but if it's your normal practice to take a break, then I'm happy to do that.
Yeah, it would be after this time of committee concentration. My own concentration tends to go a little bit after this amount of time without coffee. So could I suggest that it's 11:51 just now, that we have a short break for 5 minutes, come back at 11:56? Thank you. We shall move on, and Councillor Cameron. Sorry, I'll wait till you put your butt. I was really bad timing, Councillor Cameron, just as you were taking a drink there.
Right,
no problem, my fault. Councillor Cameron.
Thank you, Lord Provost, and I just wish to record my appreciation for all the work that's been done by our officers and Ms Tanner and her colleagues. So my question to Ms Tanner is this. As elected members, each one of us share the responsibility for ensuring how this report and new recommendations will be enacted. Specifically, what are your views in respect of how and when elected members should be informed of matters of this nature and other types of instances, for example, the outbreak of COVID, so to speak. I say this, or I ask this, because understandably we have colleagues, councillor colleagues, who hold senior roles as group leaders, etc. But ultimately we collectively share a responsibility. So I'd welcome your views on that, first of all, please. And I have a question for Mr. Kerr after Suzanne replies. Thank you, Lord Provost.
Well, thank you, Ms Cameron. I can't comment on COVID and when members should be told about things in relation to COVID, but if you're asking when elected members should be told about serious allegations being made against an employee, then I would think that it's an important part of the governance of the organisation that elected members are told at an appropriate time. There might be some restrictions to that around police investigations being commenced, but overall I would think that at the earliest possible opportunity that elected members should be informed. I don't know if you're suggesting, Ms Cameron, that there was some delay between Mr Bell being charged by the police in this situation in 2020 and elected members being informed of that. If that is your concern, it is not something that we were aware of as being a particular concern in this case. The evidence that we obtained was that matters were moved forward expeditiously, but it may be that you consider that elected members weren't informed as quickly as you could have been.
Thank you for your response. I mean, I don't know who knew before me, so to speak, so it's hard for me to judge, but I just have a general concern that serious matters of this nature and others which have implications for us as a council in relation to statutory responsibilities, I do make a plea regularly for all of us to be informed. We need to be informed by our officers, each of us, in order to fulfil our councillor duties to the best of our ability. So I thank you for that response. Lord Provost, may I turn to the Chief Executive now? Thank you. Mr Kerr, I share the concerns outlined to you by my colleague Scott Arthur in relation to, and which have been outlined in the report, in relation to basic governance in relation to note-taking and minute-taking. I mean, above all, we are a council. We're by nature a kind of statutory body with statutory obligations. And in particular, with regards to the services that we provide and the services that Mr Bell was entrusted to carry out on behalf of this council, the very least we would expect is diligent note-taking, and especially, and I say this as an HR person myself, and especially in relation to personnel records. And it was a surprise to me that nothing had been noted in Mr Bell's file about these allegations. So I'm asking you, as our current Chief Executive, how do you intend to address the recommendations, particularly ones that I believe, for what it's worth, are urgent? So things like making sure people record things properly, that they are trained in terms of the recommendations are put out. But additionally, what work, given that we do a lot of close work in other areas with the police, with Police Scotland, and so many other areas we work closely with the police, how can we as a council work together with the police in terms of addressing this problem and doing the training and awareness that we need to, and also make sure that we as elected members are fully aware, for example, if constituents disclose to us as elected members, as I've had happen, and I dare say other colleagues have had, that we are fully understanding that when something is disclosed to us, we have a duty to report that to the police, as well as obviously alerting or sharing concerns with our senior officers. I'm really surprised that wasn't, and that kind of, I hope, sets the context for my earlier question to Ms Tanner around when should elected members be alerted by our senior officers who you lead to these allegations of this type. Thank you, Mr Chair.
Okay, I'll try and summarise, I think, a number of points you made there, Councillor Cameron. So I think what's been described in quite a lot of this, and hopefully external inquiry agree with me, is some of the practices that have been in terms of, I mean, you take note taking. I would have expected a social worker, any social worker for that matter, in dealing with any subject whatsoever within their remit, to be taking careful notes, because that's what we depend upon, that's what we get inspected upon, that's what we do. What we've seem to have found is that practices have not been as rigorous as they should have been. And just to use that as an example. Now there'll be other, so I think the inquiries helpfully put their recommendations in a number of categories. One is education, which means that is training and education and making sure we're reinforcing that and making sure that people, and then there is one about just practices and culture, I'll put it that way, a culture of not putting in place the things that were already there, because some of the faults in the system that have been found out have been people not complying with what was already there. And then the last thing is there is a bit of making sure that our policies are clear, succinct, and everyone understands them. And that understanding, and that members and senior officers and junior officers equally, that we all understand how these policies work and that they're simple enough for people to understand them. And what I feel is me personally from the interface with this inquiry has been that we've got a number of policies that cross over each other, and therefore it's confusing to people about exactly what they should do under what policy when they're implementing things. So all of those will be part of the things we're going to address by next council when I bring back an action plan on the basis of the discussion today, and whatever you decide at council today needs to be done.
Lord Provost, if I may, just very quick. Extremely quick, very quick. Mr. Kerr, do we have your assurance that you will prioritise the resources to enable us to address the recommendations and to support you and your officers to carry out the will of council that's decided today?
Yeah, you can assure that. I may well be coming back and asking you for more resources, or Councillor Cameron, to enable us to do some of this, because part of the issue here is we have not applied as much resource perhaps to this area of work than as perhaps we needed to. So, but yes.
Thank you very much,
Thank you.
Lord Provost. Thank you.
Councillor Kate Campbell.
Thank you, Lord Provost, and can I echo the other councillors in thanking Suzanne and her team for what is clearly a very difficult report, but that's clearly been carried out very professionally, and also for really thanking her for putting at the heart survivors and their experience of this, and I think that's very welcome by all of us. I also wanted to thank her for the recommendations, and I appreciate that, Councillor Watt had raised some concerns, but I do think, having looked at the recommendations, that they feel very helpful, and they look as though they should make sure that any future disclosures are acted on swiftly and robustly, and that there are the right policies and procedures in place to make sure that they're escalated and dealt with. But my question really is, they are restricted to council employees, and the council has 63 councillors who act on behalf of the council. We have significant power and influence, and we interact with employees, often at quite a junior level, as well as interacting with members of the public as well. And the recommendations are very welcome, but how applicable would they be in a situation where there was an abuse by an elected member? And do you feel that there would be the same robust processes in place if that were to happen? Or do you feel that there is perhaps more work the council would need to do to put the same processes in place if it weren't an employee, but if it were an elected member that there was a disclosure about? And perhaps that's more for the future report and the whistleblowing, the wider one, but I thought it is something that, reflecting on the recommendations and thinking about how that might translate across, I feel is something we need to address. I'd be interested in both Suzanne and Andrew's views on that.
Well, obviously, complaints against elected members have not been the focus of this inquiry, but there is a code of conduct for elected members that's in the subject of revisal, and it is one of the matters that's being considered in the wider review. I don't know if there'd be anything as specific as this appearing in a code of conduct, however, but it's something we can certainly bear in mind.
Just to add to that, I was going to mention code of conduct myself. I think partly our problem is that in normal circumstances, members acting appropriately, etc., it's quite difficult to enforce with local members. The system we have, the inquiry system we have, is relatively weak in the nation. I would say that for the whole of the UK. It's weak in England and it's weak in Scotland, so our ability to take action against elected members unless there is serious allegations made. Now, if it had been as serious as the current inquiry, it would have been reported to the police. We would have treated it in almost exactly the same way. The elected member would have been suspended, and so would the report to the police been made. But if it's not of that seriousness, then it becomes a lot more difficult in terms of a code of conduct. The code of conduct for public life is something all of us, senior officers, elected members, need to be following. There's a set of principles there. It's how we apply those principles. I go back to being practices rather than the policy being wrong. I think it's quite well understood what the code of conduct for public life should be. We have to all try and find a way which we can ensure that that becomes the practice and the culture all the way through the organisation.
Okay, thank you. Councillor Webber.
Thank you, Lord Provost. I'll bring it back to the subject of the inquiry and drill down on, ask some questions around the investigation unit proposal. And it's as relevant to Ms Tanner as it is to Mr Kerr, so perhaps Mr Kerr can answer after Ms Tanner. When the recommendation says that when setting up an investigation unit, which of the two propositions would be the most appropriate in your opinion in all circumstances, internal or external, at least in the first instance? And does your recommendations, when it says acceptance in full, mean your first preference is for internal? And also, do you think it would be helpful for us to consult with staff and trade unions on some of the content of this as well?
So the investigation unit proposal very much takes account of the fact that resources are an issue for the council. There is a lot of hidden use or waste of resource in using employees who are meant to be doing completely different jobs to carry out investigations within the council in any event, although that might not be seen on the face of a set of accounts. But the recommendation here is principally made to ensure that those who work with one another are not investigating one another, but it goes much wider than that, because in response to that issue being raised in this inquiry and also in the review, we've been told that, well, in fact, sometimes investigations are carried out by people in different departments. That doesn't address the very real issue that those people have full-time jobs, they're time pressurised, they are not trained investigators. In this context, many of them have no experience of dealing with survivors of abuse. They don't know how to conduct interviews. At the very basic level, some of them don't even know how to draw up an investigation plan. So it's putting your employees in an almost impossible position and setting them up to fail, which is why the investigation unit we consider to be an essential recommendation. And for the purposes of this inquiry, it is limited to allegations of this nature. But we are looking at this in the wider context of investigations across the council in the review. So there may well be another recommendation coming in relation to the wider issue around the way inquiries are conducted in the council. So I have no strong views about whether it's internal or external, and authorities deal with this in different ways across the country. Some authorities have internal investigators who are appointed because they have the relevant experience and they can then become experts at being investigators. And some authorities use external providers. It may be that a hybrid system is the best model, and for very serious investigations, even if you have an internal unit set up, you might want to allow for the possibility of those to be sent out externally. So when we said that we would hope the recommendations are accepted in full, it is either model, whichever works for the council, but you will see that there are additional levels of protection if it's an internal unit, and those include external auditing by an appropriate body. And that's to ensure that it doesn't just become a dysfunctional internal investigation unit. So I hope that answers your question, Ms Webber.
Could I have a little follow-up, Lord Provost? Thanks. Yes, it does actually, thank you. So if I drill down a little bit on what an independent perhaps national whistleblowing service might look like for this, very much like is already in place for the NHS. And again, I think it's been suggested by a number of, or at least one educational expert, Neil McClellan. Do you think something like that would help and allow cases like the Sean Bell case that we're hearing about today be exposed far earlier?
I suppose the first point is that this isn't technically whistleblowing. So whistleblowing is defined in a different way, and there's legislation protecting whistleblowers. This is bringing allegations of a serious criminal nature to the attention of the organisation, which, while it could be brought in a whistleblowing context, not necessarily. But the NHS model to which you refer is a model that was set up following a review of their processes, and it is a very comprehensive system. And one benefit of the NHS model are the timescales, because within, and that's the timescales from the point of report or disclosure to matters actually being concluded. And that's another matter, again, that the review is looking at, because there seem to be some excessively long timescales across the organisation for dealing with investigations. But I feel a lot of that may reflect the fact that the people conducting them have full-time jobs to perform.
Okay, thank you. Councillor Mowat.
Thank you, Lord Provost, and I echo the thanks of many other members to Ms Tanner and Mr Diaz-Reney for the comprehensive and sensitive nature in the way that this report, this inquiry has been carried out, which is very, very welcome to see such a sensitive and wide-ranging report. I have just really one question about it, which is at 7.1.15 in the report, you state that in not taking action, Andy Jeffreys and Alistair Gore was a dereliction of duty. And later in the report, I think it's in the paragraphs in section 8, you talk about this being an error of judgment. And given that this potentially left Mr Bell at liberty to continue his behaviours against women for a considerable period of years, what is your? There seems to be a fundamentally different grade of wrongdoing between dereliction of duty or error of judgment, and I just wanted to understand that sort of difference in the language used and why you had chosen to do that. And given that this has led to a finding of maladministration and lack of justice under the Section 5 report, which we should be sort of really considering with this, because I think it's, most of us would interpret those two things as a dereliction of duty or an error of judgment as fundamentally different.
So the reference in paragraph 7.1.15 to the dereliction of duty obviously follows on from the discussion prior to that, and in the more expanded and fuller report there's more discussion around that, and we have full discussion of the policies that were in place at the time. Obviously the phrase dereliction of duty is intended to encapsulate something more than a failure to adhere with policies, because we do reference the fact that as vastly experienced social workers, both individuals should have proceeded in accordance with the policies, but also in the way that was right. And that is where the phrase error of judgment comes in, because those men, in respect of one of the disclosures, decided that they would deal with matters in a different way, which was for Mr Gaw to direct Mr Jeffreys to speak to the individual concerned. And that was one of the instances when nothing was noted and nothing was done about it. And that we consider to be a dereliction of duty on their part. And I don't think that's mutually inconsistent with saying that the individuals have made errors of judgment.
Can I just have a short follow-up, Lord Provost? So, Ms Tanner, when we're reading this report, bearing in mind that most of us who will be reading this are not trained lawyers, would you say that we shouldn't see them as different weightings between dereliction of duty and error of judgment, and that both are fundamentally serious errors?
Both are fundamentally serious, and there was no intention behind the use of the words to suggest that there was a different weighting in the different sections of the report.
Thank you very much. Councillor Doggart.
Thank you, Lord Provost, and may I repeat all the thanks that's been given to Ms Tanner and her team for the work done on the inquiry. Two questions for Ms Tanner and then one for the Chief Executive, please, Lord Provost. In relation to the conduct of council officers at the time, do you believe if they had followed existing policies that Sean Bell would not have been free to carry on the abuse that he perpetrated on others?
Yes, I do believe that if they had followed the policies that were in place, they would have, one, commenced an internal investigation, and two, referred matters to Police Scotland. And I don't imagine for a minute that Sean Bell would have been left in a position where he was free to carry on the behaviours that he then continued to do.
So in relation to the recommendations, what confidence do you have that the revisions to policies, the training requirements that you've set out in the recommendations would be implemented by the Council in full, not just in 2021, 2022, but in 5 years' time, to make sure that there is no repeat of what we've read about in this report?
I think the recommendations have to be seen as a package of measures, and obviously there will be employees who unfortunately choose to or do not follow policies that are in place in an organisation, but with systems such as effective record keeping and independent investigations, you can at least try to guard against those problems. The main problems that occurred here were because matters were conflicted, were kept internal, were, I was about to say were investigated, but there was no investigation, but they were considered at least by the two people who were involved in the same network as Sean Bell, and matters were not taken any further. So I have confidence that if the whole package of measures is put in place, then at least it should at least try to safeguard. But you can never account for people who decide not to follow the procedures and policies that you put in place.
Thank you for that. And a question for the Chief Executive, although Ms Tanner may wish to comment. Around the time of Sean Bell's death, two reports by council officers were presented to council committee. The first one was in relation to obtaining appropriate PVG disclosure within the Children and Families Division, and it found significant failings in obtaining appropriate PVG checks before individuals commenced employment. The second report, published on the same day, was in relation to the policy management framework, and discovered that there were significant failures in the policy management framework. The policies were out of date, policies were not subject to annual review, the policies had senior responsible officers named in them who no longer worked for the organisation. So given that this seems to be a reasonably current failing of CEC, as well as a historical failing, what confidence will the Chief Executive give councillors that the failures in the policy management framework will be rectified and that the recommendations of this inquiry will be followed through in full and reviewed as appropriately?
So I give you my absolute commitment that these policies that have been recommended and any change in policies being recommended will be fully implemented and checked and audited, etc. The seriousness of this matter is obvious to all, including myself. The only one thing I would say is PVG disclosure would have made no difference whatsoever to the Sean Bell situation, as there was no charges against Sean Bell raised anywhere. And as I think has been pointed out already, some of this is down to humans not implementing what is already there. If you look at how we implemented findings in 2020, on the Sean Bell incident, that was humans doing the right thing under the current policies and implementing that expeditiously because of the serious nature of it. Now, as has just been pointed out, you can never guarantee that every individual in 18,000 person organisation is going to comply with all these policies, etc. But we, when you see the recommendations coming by, you will see, hopefully, the action plan will see it's comprehensive, and we should be able to guarantee as much as we can that everyone understands these policies, everybody understands these procedures, and we maximise the amount of time that and the amount of emphasis that people will give to putting that into practice as we go through the next few years.
Lord Provost, could I just follow up on that, please?
Very quickly, Councillor.
Yeah, it's really, so we're talking about a significant change of behaviour and perhaps a change of management culture, leadership, than anything else. So what practical steps will you implement and your senior management team implement to make sure that as many employees as possible do indeed follow these recommendations?
So I'm reluctant to give you an answer now when we haven't prepared a fulsome reply to the recommendations yet, but actually it's going to be a mixture of education, training and reinforcement of behaviours and checking back whether those behaviours have been implemented. And hopefully you'll be able to see that when we put the action plan in place.
Thank you. Councillor Aldridge.
Yes, thanks very much, Lord Provost, and thanks to the inquiry team and also to the team at Pinsent Masons, who were very welcoming and accommodating during a very harrowing afternoon. My questions really relate to one of the answers I think that Andrew Kerr gave about employees needing to know what they should do. And there are two elements in the report where I was a bit confused. One is the element about gossip and rumour and at what point people should act on that. And clearly in the Sean Bell case it was overwhelming, but I think people need to know at what point the informal gossip and rumour is something to act on and at what point it might simply be an unpopular member of staff being ganged up upon. That's, if you like, for the future. And the second one sort of relates to that, and it's about whistleblowing, and it's, is there a point at which the option of whistleblowing becomes, if you like, an obligation, a duty to whistleblow? And I wasn't really quite sure if there was a point at which you crossed a line to it being a duty to whistleblow.
Mr. Aldridge, was that a question for me?
Yeah, maybe for both of us, was it, Robert?
I think it was really for both of you. I wasn't quite sure who would be best to answer.
Well, perhaps I might just start on the first point in relation to employees needing to know what they should do, because it was a very real issue in this investigation that there was a lot of rumour and gossip and speculation around Sean Bell's behaviour, and I hope that the general recommendations that we're making around identifying inappropriate and unacceptable behaviours would assist all employees, even if they are friends with the person disclosing to them, to consider how a matter might be appropriately dealt with. Because in a sense, and to go back to a point that Councillor White raised earlier, that might prevent missed opportunities. And that also takes into account that the training would include the fact that if somebody is subject to domestic abuse and coercive control, they might be extremely reluctant to progress matters. For the person to whom matters is disclosed may then have a duty to refer matters for investigation and to Police Scotland. And there should be an open culture in which people feel that these matters can be raised. And to go back to Councillor Watt's issue earlier about impediments to disclosure, it may have a dampening effect on disclosures if individuals think that everything they say to everyone else will be referred on. But I would hope that that's not the case. If you're moving towards having a more open and transparent organisation. So at what point people should act would very much be part of the training and would include the more informal type situations that are mentioned in the report. There will always be a line though between gossip and rumour and speculation and an informal disclosure. And there will be many situations where there's gossip about unpopular members of staff or not liking what somebody is doing in the workplace, or perhaps a bullying complaint, which is entirely different really from what we're talking about. And it's enabling your managers to know where to draw the line and when to make the call, and perhaps err on the side of caution in relation to matters that should really be treated as informal disclosures by employees. In relation to whistleblowing, I think I mentioned earlier that whistleblowing as a term encapsulates a different sort of complaint, although it may include some of the sort of matters that we're talking about. The Council, in fact, defines whistleblowing more widely than the statutory definition of whistleblowing, and that is an issue that we will deal with in the review.
Yeah, and Councillor Aldridge, maybe just to add to that, which Suzanne's outlined, there is always going to be a point where there's a level of judgment to be applied, particularly if you're a management personnel, in terms of it's why policies cannot cover absolutely every possible aspect of behaviour by staff, etc. And there is always a judgment to be made. Actually, maybe what we need to make sure is that we've got people who are trained appropriately to make those type of judgments on a regular basis, whether they're brand new managers or brand new issues. And to say that, we do try and do some of those things, because we have got any new manager in this organisation, for instance, has a training programme to go through. And some of those judgments and culture issues I know come up because I address those groups. But there's always some kind of judgment to make. Obviously, in this case, you had very senior people making judgments, which has been found to be an error. And I would have expected people with that experience of social work to be making the right judgments in those cases. And obviously, it didn't happen. But I would have hoped that that was not the case right throughout social work, for instance, because social workers understand these issues maybe as well as, and maybe better than, most other employees in this situation.
Okay, thank you. Councillor Mitchell.
Thank you, Lord Provost, and thank you, Ms Tanner, for the report and your team's work. The two lawyers in the room with me were really accommodating and with what was a really, really difficult afternoon. I'd like to sort of touch on things that have already been spoken about, which is about process. And the Chief Executive has talked about that there were very clear policies, and we've got recommendations for a package of policies that are supposed to, prevent this from happening again or make it a more robust process. But what I've really struggled with is that if we had a really clear set of policies and we had really highly trained people that were supposed to be able to implement those, that didn't happen, and how anyone is really supposed to have confidence in what's being recommended here. And that goes for councillors, officers up and down the chain, and indeed the public and service users, to be able to think that this new process that you're suggesting is actually going to work.
Well, we wouldn't have recommended it if we didn't think that it was going to improve matters. And as I said, it's not one recommendation taken alone. It is a package of measures which, when taken together, will hopefully deal with the majority of the issues that have occurred in relation to Sean Bell's abuse and the way that it was dealt with over many, many years. As I think both myself and Mr. Kerr have already stated, one can never account for the actions of a particular individual, but what I can say is that the organisation should be more robust so that it can cope with the individual who decides or does not follow the policies that are already in place. And there are some policies that could be made more clear. For example, the policy on domestic abuse that we've referred to in the report should be explicit on its face that it covers conduct occurring out with work hours and off work premises. Now, we interpreted the policy as it exists as covering that when we were conducting the inquiry, but to make matters as clear and obvious to employees and managers as possible, it should be on the face of the report. That's a very easy change to implement and to educate around. And that is the beginning, I think, of educating people. I can also say that as the years and decades have moved on, society has changed, and one would hope that an old boys network of this type wouldn't be able to begin and permeate itself into a department in the way that occurred in this case. And if it was, I would hope that it was called out.
Okay, thank you. Andrew,
could I ask one?
I think Andrew wants to come back on your initial
just
question.
A very quick addition to that. There is a difference between policy and practice. The point I was making out, Max, that if people apply good practice, our policies may not have been perfect, but they would have dealt with this incident, and it was dealt with appropriately by senior people with our current policies to deal when it was discovered just recently. And that's because that experience and the way of dealing with it was available then and was implemented where it very obviously wasn't previously historically. And we have to make sure that that's more consistent. And as Suzanne pointed out, the organisation is more robust in applying those policies and making sure our policies are the right ones and then applying them appropriately.
Thank you, Andrew. Councillor Mitchell, quick follow-up.
And thanks. And are the policies going to then be robust enough to ensure that if failings occur again, that there are actually going to be consequences for those that fail to implement them? Because it seems like, for at least my reading of it, and what really stuck with me is that there are no consequences.
So I'm not sure that's correct, Councillor Mitchell. There are consequences if this was discovered in normal circumstances. There's always consequences for both the council and the police to take action in these incidences, and there is again judgment about what those consequences and how far you can take policy and procedures, but failure to follow policy is a disciplinary matter.
Thank you. Councillor Munn.
Thank you, Lord Provost, and I'd like to thank Ms Tanner for her report and the recommendations. And my question is about it's 7.1.14 of the report about the dossier and the circulation of the dossier. It's stated there and in the wider report that this dossier was circulated widely within the council, and there were questions when I attended St Mason's about that and about how it was circulated, and I believe it appeared in people's inboxes, old-fashioned inboxes, not electronic inboxes. It was a physical document, and I wanted to ask, because I see the explanation in the report, and the public can see that if they've read the report, that despite the allegation that a former chief executive may have seen it, and we've had an answer to that, which you stated earlier, you weren't able to verify who it was circulated to. It says confirm exactly who received the dossier. I just want to ask a bit more about that. Why would that, if it had been circulated so widely, and the inquiry spoke to so many people, that there's no real evidence other than this assertion that a former chief executive may have seen it?
So the dossier is a reference to a document that was produced on an anonymous basis by an employee in 2011, and it was a not insignificant document in terms of length, but in summary it included an allegation that Sean Bell had committed abuse against another employee. And it also included allegations in relation to misuse of public funds. And the document was disseminated on an anonymous basis by, as you refer, Mr. Munn, the old-fashioned method of putting in people's pigeonholes. The person disseminating the dossier did not keep a list of who it was given to. there was no way for us to verify exactly who had received a copy of the dossier. We spoke to the author of the dossier. That person was one of the witnesses to the inquiry, and that person cannot say for definite who had sight of the dossier. And as you've already mentioned, the suggestion that was made by another witness that the dossier was disseminated far and wide and made its way to the Chief Executive has now been put to the Chief Executive with her comment attached. What it did lead to, the dissemination of the dossier and some associated complaints that were made by 2 employees, were 2 fair treatment at work investigations and a public interest disclosure investigation, to which I've already referred in relation to the misuse of funds. So it did lead to action on those points. Unfortunately, it did not lead to appropriate action in relation to the abuse of an individual, which is the type of abuse that we referred to as being strikingly similar to abuse that had occurred on Elaine Sampson, Mr. Bell's first wife. And had that been actioned at the time, that would have identified a pattern.
Okay, thank you.
Thank you. I had a question for the Chief Executive as well.
Yes, Councillor Hunt.
Andrew, you stated quite clearly the action that was taken in 2020, and that's to be commended, because that's led to where we are today and led to disclosure and understanding of what had been going on for far too long. I think it's come out in other questions, but I just want to clarify it. Is it the policies that we now have in place that led to that swift action? And what do you have a view on why, despite senior officers within the department knowing in the past, from my reading of the report, that is it just down to the policies, or are there other aspects there that because people have mentioned, we're talking about a social work department here where staff are highly trained in identifying things like abusive behaviour and coercive behaviour, and that was the thing that hit me so hard when I read the full report, was the way that was not addressed by people who should really have known a lot better. So I've kind of rambled there, but the question is, you've taken swift action this time round, and I applaud that, but why was that not the case before? Is it just down to the current policies?
I don't believe so, Councillor Munn. However, what I would say is, it wasn't just me that took the appropriate action. This was the head of service who did the right thing in getting reported to abuse, then reported it to our director. Director reported it that day, came to me and said, "This has happened, we need to take action." We did, and that's what happened. We immediately implemented that which has been described. Now, I am at a loss to understand why this is human beings interacting, of course, and why that didn't happen previously, because I don't think it was particularly a weakness in policy. I think any senior manager, never mind a social worker, would have understood the need to investigate, at the very least investigate, and find out whether there was a real situation to be dealt with, rather than exactly what happened. And I'm at a loss why that didn't happen. But I think the policies were obviously strong enough that we were able to take in that specific instance. But most of it was logic and common sense about what you had to do. This was a serious issue, had to be reported to the police, had to suspend the person responsible. I had to implement an investigation. So human beings involved, again, go back to human beings involved in delivering policy. Sometimes, no doubt, our policy isn't perfect, but I think we need to make sure the policies are better, make sure our practice is embedded much more clearly than it perhaps has been, and that's what we need to continue to do. But for the individuals concerned, I don't understand to this day why that wasn't implemented.
Okay, thank you. Councillor Jim Campbell.
Thank you, Lord Provost, and like other councillors, I'd like to thank the inquiry for all their efforts. And also I find the hosting of Vincent Masons to be very agreeable. I have two short questions for Ms Tanner and then a question for the Chief Executive, Lord Provost. My first question, very short. Is all the material that you've gathered as part of this inquiry, and have all the witnesses been given the opportunity to contribute to the review that is still underway?
So, although the inquiry and the review have been running effectively simultaneously throughout the period since November last year, they are looking at very different issues. There is some crossover of issues that have been raised, and yes, there are a number of witnesses who have contributed to both the inquiry and the review, and the teams have had a system for identifying when people first contacted us, whether it was more related to the inquiry or more related to the review. But we have spoken to a number of witnesses in relation to both matters. And in fact, there's been consent for statements provided in relation to one matter to be transferred over to the other matter. And so although they're running as entirely separate inquiries with separate teams, there has been a certain amount of crossover with the consent of witnesses. And yes, there are clearly issues of a thematic nature that have arisen here, which are highly relevant to the review.
Thank you. And my second question really relates to Councillor Munn's earlier question about the dossier. I understand that Unison, the union, wrote to the Council on the 3rd and the 12th of October 2011 to express concern that Andy Jeffries was involved in this investigation, suggesting their concern was due to their belief that he was directly implicated and had a potential conflict of interest. If the union was writing to the council, does that not suggest that the dossier might have been in quite wide circulation? And I don't know if the inquiry has considered the possibility that the dossier might also have been circulated to senior councillors at the time. And so therefore, this information might have really been quite widely known, and it seems incredible, that being the case, that no action resulted at that time.
Well, in relation to Unison writing, when you say to the council, is that because you have had sight of letters to a particular individual within the council, or is this simply second-hand information, Mr. Campbell?
Thank you. I'm afraid it is just second-hand information, but I understand it to be accurate.
Well, I might need to defer to Mr. Diaz-Rainey or Mr. Richardson on this point, because I do not recall seeing any copy letters from Unison to the council on this point. So that's not something that I recall. And if a potential conflict of interest had been raised as a particular issue, then one would have expected that to be acted upon. But I suppose it depends to whom the letter was sent at the time, if it was so sent. And I think I've already answered the point about circulation of the dossier. And I don't understand that there was any evidence provided to us that councillors had sight of the document at the time.
Suzanne, just if I can step in, I agree with what you just said, and we will check the point, but we don't believe we've seen any letters from Unison, but we will check it.
Okay, thank you.
Thank you, and I apologise if my information turns out to be wrong. My substantive question is actually to the Chief Executive. I mean, you're an experienced Chief Executive, Mr. Kerr. I don't know what you expected to find when you joined the City of Edinburgh Council, but the part of the inquiry that really struck with me was actually Disclosure 1. And I know that you have seen the full report as well as the public report, and you'll be aware in the full report there's some very specific allegations about that Disclosure 1. If that had been reported at the time, or if that report had been sustained at the time, we might not be in this position now. because it seems clear to me that some employees at the time suspected wrongdoing. Are you confident that if the same thing happened today, or indeed had happened any time since 2015, that employees would have the confidence to sustain their concerns and that the matter would be addressed?
I don't know if I can say I'm confident. As you're right to say, I'm an experienced chief executive in very large organisations. The openness and transparency, etc., of course, gets generated sometimes by the senior team. I think I've currently got a very open and transparent senior team, but whether that means that all the way through management that these things would have been disclosed is another matter. And I'm actually sure that in the culture review, some of those issues may well have come out in those issues. We try. You can only do so much in lots of ways to be open and transparency. Some of the issues around in a local authority in particular, actually, around openness and transparency, is the fear of it being in public, is the fear of it being exposed that way in open forum, etc., etc. And it's part of the nature of a political organisation. That's what it is. And I don't think we're any different in that way than any other council is. But if you think if I disclose something and it's not found to be entirely accurate, and then that appears in public, wherever that appears in public, at committee, or whether it appears in the papers, or whether it appears in anywhere else, then that does create some level of barrier to people being open and transparent about everything. If you're in a private organisation, it is easier to be more open and transparent because it isn't exposed beyond a management situation, and that's my direct expression. I've experienced a number of, not the same as Sean Bell inquiry, but similar, where it's taken some time for the real truth to come out because of that fear of exposure in public being the barrier to it, and it's something we probably have to deal with every day. It's not an issue that's easily dealt with in terms of culture.
Thank you. Lord Provost, I wonder, I accept the difficulty the Chief Executive describes, but I wonder, do you feel that you and your senior management team would at least be confident that they could spot something like an old boys network or a similar network that might exist elsewhere in the council that was really trying to stifle that degree of openness? Would you at least have the confidence we would spot and stop that today?
Well, I think that takes experience and knowledge and direct things. So I'd be confident we'd have a good chance. Now, whether we export to the extent it's just been exposed in the Children and Families Department, for instance, is an entirely different matter. I think I was as shocked as anyone else at the extent that appears to have been the case, even if that has been historically the case. And quite a number of those people, as undoubtedly will, when we investigate further, we'll find are no longer with the council, of course, although some may still be.
Okay, thank you. Councillor Perry.
Thank you much, Lord Provost. I was going to ask a question on our whistleblowing policy, but I think Ms Tanner said we'll be dealing with that in the next report. If we are, I'll save my questions for then, as long as I get that confidence that it's going to be in the next report.
It will be centre of the next report, Councillor Perry.
Thank you. Excellent. I like these types of questions. Councillor Child.
I'm going to save my question for the next report as well, because I think it's more relevant there. And a couple of answers that Andrew has given, basically answers the fundamental question I was going to ask.
Thank you, Councillor Child. Councillor Gardner.
Thank you, Lord Provost, and also thank you, Mr Tanner, and your team, and also thank you for putting extra dates on for those councillors that were unable to attend during the week of recess. And I would like to particularly thank Mr Richardson, who took a great deal of time to answer questions to me and other councillors that were present, and went really beyond the call of duty. So I'd really like to thank your colleague there, but also welcome the report and its recommendations. I just wanted to pick up on an aspect of it, and it's right that the report centres around the survivors, and it's also very true that the abuse was carried out by Sean Bell. But it was something that Councillor Mitchell referred to about consequence, and it seems that in the report itself you've mentioned dereliction of duty and error of judgment, and two very senior members of staff chose to resign, one rather than face a process. And so it's really, and your report is very much about processes and looking at the organisation. So it's not necessarily to be vindictive against those two individuals, but it's really to look at the process, and does the council perhaps have a duty to, once people leave, they're no longer employees, but they've acted on behalf of the council and they've left a legacy of behaviour. And so it's really, is there a need to complete that circle, as it were, because actions have consequences, and these are senior members that could have prevented future, if they didn't intervene at particular points, it might have actually addressed issues at the time. So it's really to hear your view, and perhaps Mr. Kerr's view as well, on that, and whether we need to build in processes for former employees that have left in these sort of circumstances. Thank you.
Well, I would start by saying that both Mr. Jeffries and Mr. Gaw cooperated fully with the inquiry and were represented, were interviewed at length by the inquiry and had the opportunity to make their positions known. Both of the individuals took part in the representations process, colloquially known as the maximisation process, with representatives if they wish to do so, and raised factual issues at that stage. So they were able to fully take part in this process. In respect of Mr. Gaw, he resigned from the organisation last year. In respect of Mr. Jeffries, he resigned from the investigation after he'd taken part in the maximisation process for our report. At that point in time, Mr. Jeffries was involved in a disciplinary investigation that was being conducted by senior officers, which was, although running alongside it, nothing to do as such with our inquiry. It was no part of the work of the inquiry team, and it would have been entirely inappropriate for us to be involved in a disciplinary investigation into Mr. Jeffries. But I think the question you asked Mr. Gardner is, should something along the disciplinary line have continued despite him choosing to leave his position with the organisation? And from a perusal of your disciplinary policy, there's nothing explicitly stated in it that says that disciplinary investigations can continue after an employee leaves, although it doesn't exclude that as a possibility for a way to proceed. The issue one might question would be what the outcome would be, because obviously when you're disciplining somebody within your organisation, there's a range of outcomes, and it's difficult to know what an effective outcome might be for someone who's already left the organisation. As Mr. Kerr has already referred to, the SSSC, which is the regulatory body for social workers, has been informed of all matters and was awaiting the outcome of our report prior to considering matters again. So that is a form of consequence, that at least matters are being looked into by the regulatory body. I don't know if that answers your question, but Mr. Kerr might be better placed to discuss the disciplinary side of things.
I think it largely addresses, it was just about whether our processes need to complete the circle, and you kind of answered it. It's obviously, Councillor Mitchell referred to the lack of consequence, but maybe the professional body might be the place that can take that up, because also these people have retired and there's no apparent consequence other than the loss of reputation perhaps and leaving the service early. But I'll go to Councillor, I'll go to Andrew, if that's okay now, because I think you've answered as best you feel able. Thank you, Susan.
If I'm being honest, Councillor Garn, I would prefer to, there's a recommendation going to come that says I should provide a briefing note for councillors about the circumstances around these particular individuals, which I would prefer to do, given that they are about individual circumstances. But what I don't agree with is, even in the circumstances we've just described, is there's no consequence for these individuals. There is a judgment to be made in all disciplinary processes, and as Councillor Campbell just pointed out, I'm an experienced chief executive who's been through many disciplinary processes in my time, unfortunately, as part of the job. There is a judgment to be made about the outcome, as I think Suzanne just pointed out, about what is the end outcome as a result of going through disciplinary processes. And in this case, I was very well aware we had a survivor-led process going on, which would have had to be repeated over a number of months with the same type of interviewing for those survivors, those people involved in this, etc., to come to any kind of conclusion, particularly in the case of Mr. Jeffries, who of course resigned during disciplinary process, for us to carry on those matters. And you take all of those things into account, the effect it has on the person. We are required to look after the person's well-being, no matter what circumstances we find themselves in anyway, as part of our policy. And we're required to think about what the consequences are about the other people involved in those disciplinary processes. And we took the judgment, not in Mr. Gaw's case, but Mr. Jeffries' case, that we should not continue with the disciplinary process to deal with those issues, which I will fully outline in the briefing note that I will give to councillors, should you agree that in the way forward.
Okay, yeah, I'm happy for the briefing note, but will that cover procedure as much as these two individual cases that you've mentioned?
The disciplinary procedure, to my mind, is A, very common right across local government, B, has a connection to national circumstances, and as far as the Social Care Council concerned, they will have to decide whether there is any disciplinary action required in the case of Mr. Gaw and Mr. Jeffries going forward, once this external inquiry has been concluded.
Okay, thank you. Councillor Hutchison.
Thank you very much, Lord Provost, and I'll echo the thanks of many colleagues so far to Ms Tanner and everyone at St Masons for their work on this very sensitive inquiry and for their accommodation and allowing councillors to go in and read the report and to answer our questions. My questions for the Chief Executive. These issues came to light in 2020. As has just been mentioned in your exchange with Councillor Campbell, you are an experienced Chief Executive. What have you changed specifically since 2015 that gives you the confidence and can give us the assurance that the chances of something like this happening again are minimised in future?
So I don't want to spend an awful long time doing this, but an awful lot of work on attempting to get more corporate culture right throughout the organisation, an awful lot of training on for managers on what we call the light they shed. In other words, their actions being watched by other members of staff, etc., and a number of changes in personnel at the top of the organisation that I hope have created a more open and transparent culture at senior management level. But of course, we are dealing with human beings. I go back to the same issue. You can never guarantee those things. So an awful lot of work in a time where I think all of us recognise there was less and less resource to do this type of work, to make sure that we had an extensive set of training on both culture and principles of public life, and that's been, and then a whole bunch of stuff around better communication from senior management, more openness with communication, visibility of senior management, etc. Well, the more obvious example, to use mine because I can more easily recall it, is that I do my weekly vlog to staff for people to listen to about what's going on in the council, how we're doing things, how we do those kind of things, and quite a lot of my senior colleagues do the similar, and that type of thing. A manager's news, colleagues' news, the HR policy has been easily available on the website, etc., etc. So a whole number of things. It's quite a complicated question just asked, but I could, if we had the time, and I don't suggest we do that in the council meeting, I'm very happy to outline that elsewhere so that people can judge whether we're doing enough or not.
A very quick follow-up, if I may, Lord Provost, on that. Yes. Given those changes that have been made, Mr. Kerr, why, in your opinion, did these issues not come to light between 2015 and 2020?
Individuals making those decisions not to.
Okay, thank you. Councillor Brown.
Thank you, Lord Provost, and at the risk of repetition, join colleagues in thanking Ms Tanner and Pinsent Masons for their due diligence and their report, and also the accommodation of the offices to allow us to go in out with the previously scheduled timescales to read it. The full report, which was quite a harrowing read throughout, records the fact that Sean Bell was the chair of a domestic abuse charity. Can I ask Ms Tanner why this was not included in the summary report? And a couple of other questions around that. Did the council refer victims of abuse to this charity? And also, did the council provide any references for Sean Bell to get the role in the first place?
Well, I can answer the first question, Mr Brown, in relation to the report, which was that in producing the open report, what we had in mind was distilling the most serious allegations, our findings, the relevant observations and our recommendations into a document that was easily accessible, that took into account the wishes of the survivors who wished for their identities to be known, and that took into account other considerations. And I'm not suggesting that for any of the other considerations was one point about his chairmanship of a charity left out, but it wasn't considered to form one of the central matters. Well, clearly it is included in the full report, which has been viewed by many of your number and also provided to the council. A decision had to be taken on removing a lot of material from the report, and I hope that what was produced is an accurate summary of the main substance of the sexual allegations involving Sean Bell. The other questions, I think, are probably for your own organisation.
That's right. Councillor Brown, I just don't know the answer to the questions you've just asked, whether we give reference to the domestic abuse charity or not, but we'll make sure we investigate that after today.
Okay, thank you. That concludes the questions that I have from elected members that we can deal with in open session. If we cast our minds back some 3 hours ago to one of the first questions that Councillor White asked, I think it was clear from Suzanne Tanner's response that we couldn't deal with that in public. I'm now going to suggest that we move into closed session to deal with that question on its own, because I'd like to finish questions and release Suzanne and her team before we go to lunch and allow them to get on with the rest of their day. So if we can, Gavin, if we can move ourselves to closed session, and at that point, Councillor White, if you could, just certainly for my memory, repeat the question so that it's fresh in our mind, that would be appropriate. Gavin, if you can let us know when we're in closed session.
Thank you, Lord Provost. That's us live, Lord Provost.
That's super. Thanks, Gavin. I'm not going to waste time with a roll call at this moment. I think it's important that we get on to the substance of the debate, and I'm sure everybody's interested enough to be back in time. So, Gavin, if you want to take us on to the order of business.
Thank you, Lord Provost. Yes, so we are back on item 3.1, investigation reports. The A and the B report is taken as a whole, and we have an all-party motion which has been circulated for this.
Okay, that's super, Gavin. I'll just remind everybody we had a fairly open session this morning. We're back on standing orders now, so it'll be 5 minutes for movers and seconders, 3 minutes for other contributions. And to move the recommendations and the all-party amendment, Councillor McVeigh.
Thank you very much, Lord Provost. And again, I want to start by thanking the survivors and expressing my sympathies to them and those affected by the behaviour of Sean Bell, the conduct of Sean Bell, and also echo the apology that the Chief Executive made in introducing the report, and also obviously has sent to the 3 named survivors individually in letter form. And I hope very much I speak for the entire council chamber in doing so. I also want to thank Suzanne Tanner, the investigation team at Pinson's, and those who have come forward as witnesses, who have been the underpinning of the information and indeed the conclusions and recommendations of the inquiry. Well, Provost, our job when presented with circumstances like this is to take actions which give us the maximum level of assurance that we can get that this can never happen again. And I want to note that during this council term, there have been 2 disclosures which underpinned the information presented to us by inquiry. And in the first of those, the inquiry gave no criticism of the council, and in the second, conclusion was that the council dealt with things appropriately. And obviously that led to the exposure of these issues, the subsequent police action, and the beginning of disciplinary action with the council. But I would say the failures go back 25 years in dealing with this, and it's incumbent upon all of us now not to simply dwell on the most recent actions, but to look at that entire timeline of failure of action throughout that, in making sure that we can respond proactively and address these issues. And in that, I want to acknowledge the collaborative approach that all parties have engaged in. It's unusual, Lord Provost, for the parties to table all-party amendments, and I do want to express my gratitude to all the parties for the way they have engaged in this to get us to that position, because it's incumbent upon all of us to work together constructively in the best interests of our council and our 18,000 employees, of whom we owe a duty of care, and to the 520,000 people in this city as our constituents. I do want to change, Lord Provost, paragraph 1.6, and I know committee services have sent a revised version out of this. I'll just read out what I'm now proposing 1.6 reads as, which should read as: Council therefore apologises to the survivors in light of the appalling experiences as highlighted by the independent inquiry, and more generally the Council apologises for its corporate failings and their impacts as identified in the independent inquiry. I think that is important. I think it's important for the Council to acknowledge not just the individual impact to the named survivors, but beyond potential impacts. And we heard some of this from the chair of the independent inquiry, that there are aspects that we don't know about potentially now. And it's important that the Council establishes one, a redress system as articulated and recommended in the report, so that people can have access to that, and also that the Council expresses in a wide sense that it has failed in addressing these things. I do want to end by saying I think we are absolutely united as a chamber on this. I think the length of questions, and indeed the nature of questions from all quarters of this chamber, show that we are all in exactly the same space as wanting to find a way forward that puts the welfare and well-being of our citizens, our service users and our staff at the absolute heart of our services, and find ways of addressing things and strengthening our processes to make sure that faults of the past cannot be repeated in the future. So I'm more than happy to propose the all-party position, and very much hope that Council unites behind it. Thank you.
Thank you very much, Councillor McVeigh, and I'm happy to accept that amendment, late amendment to 1.6 in the all-party amendment. Councillor Day to second.
Thank you, Lord Provost. And again, thank you to Ms Tanner, to Julian, Alex and Hannah and the rest of the investigation team for a thorough independent report. I know the survivors have felt open and able to speak with them and bring everything out into the open at long last. Can I join the council leader in setting out our full apology to the survivors for the failings that we've all now had set out clearly before us today. It's the courage of the survivors to come forward that will make us force these changes through for the future. And I would like to echo the Chief Executive's apology to the survivors. So to Tricia, to Emma and Elaine, I'm sorry that we failed you and we let you down. I spoke earlier of the Old Boys Network, and I'm reassured from Ms Tanner's response that this will of course form part of the subsequent report across the council, and I look forward to being able to influence that report. I also raised what I understand to be the failings of the SSC, who were advised of Sean Bell's cases of abuse some time ago, but seem not to have taken any action despite a lengthy review, and I do think that's something the council needs to take up with SSC. Earlier, Councillor McVeigh and I raised questions about officer and member cooperation and engagement, and I'm appalled to hear from the QC and in emails from Mr Diaz-Rainey at the behaviour of an elected member of this council, given the seriousness of this topic and the issues being investigated, that members ought to consider their positions. But let's not allow that totally inappropriate behaviour to detract us from the main issues about the abuse of women by a senior social worker, Sean Bell, and the failings of senior officers to follow correct procedures that would have stopped the horrific violence and sexual assaults of a man who I hope rots in hell. Lord Provost, reading all of the documentation as I have leaves no stone unturned, and I'm grateful for the survivors' openness and honesty and courage to stand up and tell of their experiences that no one listened to or acted upon for many years. But I do want to put on record as well the professionalism of the social worker that did follow the correct procedures, and to Bernadette and to Andrew for ensuring that when we did find out, immediate action was taken to stop this vicious attacks and behaviours. Lord Provost, survivors have told the investigation team they do not wish politics to be played here, and I certainly won't be. Today for me must be about the survivors and ensuring that this cannot and will not happen again, and that we in the council do everything within our powers to prevent any of this from happening again. And seconding the cross-party addendum, I also want to thank the group leaders for coming together amicably on this serious issue, and that all of us must now ensure the recommendations are delivered in full. Thank you, Lord Provost.
Thank you very much, Councillor Day. And we'll go to member contributions now. Councillor Dickey.
Thank you, Lord Provost. In thinking about what to say today in response to this investigation report, there are really no adequate words. Even the words of this motion apologise to the victims for their appalling experiences, and appalling they've certainly been, or thanks the survivors for their courage, and courageous women they certainly are, but they're still not far from sufficient. So I think I'll use the words of an individual who'd went to the inquiry who emailed me last night. She wrote, "I really hope that tomorrow's full council is the start of something for the council rather than a full stop. You see, there's a danger that we could come to this virtual chamber today and think that the inquiry report is a full stop, and we'll mainly just get on with business as usual. This will, of course, depend on how much change you felt was needed in the first place. This cannot be a full stop. This has to be a fresh beginning. I'm conscious that survivors will be watching this debate, women at the heart of the report, other individuals whom the inquiry are aware of and have also been abused, and maybe others that are yet too frightened to speak out. The consequences for the survivors are long-term and far-reaching, and this is not the end for them. I think survivors need a sense of hope from us today, especially they have relived their trauma to show us what needs to change. And the witnesses who contributed knowing something was wrong in this place. Old Boys Network, untouchable, protected, investigating each other, surprisingly clear HR records, victims and complainants not being believed, intimidated, discredited, safer to stay silent. These are all familiar words because they've been shared by a good number of individuals who have come to me in desperation for any help. Some having felt forced to leave the jobs that they loved, or enduring every day with deep anxiety. Even this week, 3 people came to me. I want to thank Suzanne Tanner for listening and finally ensuring the voices of the survivors were heard. Taking time to genuinely listen is such a vital task. This open and transparent public airing of these serious issues is one healthy step forward, as is embracing recommendations which seek to create an environment where no one feels intimidated, discredited or fearful for raising concerns and complaints about abuse in all of its forms, and where we move away from networks investigating and protecting each other. To conclude, a healthy culture is a professionally curious and zero tolerance culture. And if we are to prevent further behaviour and system failures, it starts with being open to the possibility that there are other survivors out there who may now come forward, and possibly with other old boy network names too, and we must not do anything to shut this down. And through this package of recommendations, we'll seek to genuinely and impartially invite, listen to and act on concerns. It should not be a full stop. This should be the start of something fresh. Thank you, Lord Provost.
Thank you very much, Councillor Dickey. Councillor Miller, please.
Thank you, Lord Provost. And just before I begin, my contribution, I would just like to associate myself with those remarks of Councillor Dickey. She's spoken passionately there, and I agree wholeheartedly with her on her contribution. I would like to begin by paying my tribute as well to all of the survivors, both named and anonymous. I sat quietly and took a lot of time to read your testimonies in the full report when I went to visit Pin St Mason's offices. And I bear witness to the abuse that you have suffered, and I am so sorry that you went through this, both the abuse that you've suffered and also the failings of this council. I also feel sorrow for the loss of potential justice in court, something that we can't change for you, but which I feel keenly as well. I think it's important at this point in time to pause and reflect on the harms that have been caused, and I can assure you all that I have been taking the time to do this fully. In conversation with the inquiry team, by querying our chief executive, and by taking time to quietly reflect and absorb the enormity of what you've reported to us. Our next steps in the council will be critical, and so I am going to be keeping your experiences and your needs at the centre of this as we take our next steps and take action. I am glad to have been able to spend time with Suzanne Tanner and the inquiry team, to be able to ask them about the inquiry process and the reasons they reached their conclusions and their recommendations. I have been completely assured that they have taken a survivor-led and survivor-focused approach, and that has ensured that their recommendations are the right ones, and that we will be implementing the right choices and taking the right actions to prevent future harms. So looking ahead, I'm thinking about all of the residents across Edinburgh who we serve, including current and potential future service users, their families, their friends and their loved ones. Implementing the inquiry recommendations in full and at pace will enable us to serve them without the risk of future harm. And that's the task that I'm looking forward to now, to ensure that survivors are not only heard and believed, but that we make the changes necessary to serve and protect our residents in the future. Thank you, Lord Provost.
Thank you, Councillor Miller. Councillor Watt.
Thank you, Lord Provost, and my thanks also to Councillors Dickey and Miller for their contributions. I very much hope that the survivors involved in this and other survivors of abuse will continue to speak up for themselves, and we will show a willingness to listen, that we will no longer allow survivors to be discredited and victim blamed by people who don't want them to be heard. That is a thread that runs through this and through too many similar situations. It was essential that this inquiry was independent and that future policies, processes and working practices in this area are subjected to independent expert scrutiny and monitoring. But we must not think for a minute that we can outsource our responsibilities for this going forward. Within the council, we have excellent officers who are experts in the field of domestic abuse policy and training. Sadly, they have not always been listened to, nor given the respect that they deserve. Too often, minimising the Council's potential risk of liability has been the focus of policy in this area. There has been far too little understanding that taking a survivor-focused approach is the way to minimise the Council's risk. This is the hard lesson that we should learn from this inquiry. In future, we, as elected members, must be willing and must be permitted to take a more active role in scrutinising policies, procedures and operational practices in this area. I sincerely hope that we can look forward to equally safe, actively informing everything we do, and that its core principles become built into the culture of this Council. If we do not do this, we will be back here again, listening to another QC telling us that we have failed to learn the lessons from this heart-wrenching experience. We absolutely must take responsibility for this now and in the future. And as Councillor Dickey said, this is not an ending. This is a beginning. This is a chance for us to have equally safe in everything, at the heart of everything that we do. Thank you.
Thank you, Councillor Watt. Councillor White.
Thank you, Lord Provost. This is one of the most difficult debates I've had to take part in, having been councillor now for a considerable number of years. And I am grateful to colleagues across the parties that we've come together to agree a way forward. I'm grateful to Councillor McVeigh for accepting a number of requests I put into that process, and which are included in what we have before us, and that we are making the apology we as councillors can make on behalf of the Council today at paragraph 1.6 as adjusted. That apology, of course, primarily goes to the survivors who are named in the report, but it's also to any others out there. And we also have to apologise to staff that have been let down through the processes, or rather the practice over the years that allowed Sean Bell to perpetrate his abuse over a number of years, after missed opportunities, after times when senior people in this organisation should have stopped him, knowing that potentially it was behaviour that would continue. We do need to consider how we address it as a council, Lord Provost, and that means all of the things that are in the political agreement we have before us. We do need to consider further whether to have another investigation of the misuse of public funds issue. We may not investigate that, but we have to consider that appropriately in light of more information. We need the briefings that we have requested, and we need to look at the full issues for the future to make sure that in setting up an investigative unit, it gives assurance to all of our current and future staff, and that we review our policies. What went wrong here was that people didn't comply with our policies. But in part, that is because we have a great many policies that are often contradictory and confusing, and that gives managers problems. We should give them clarity so that we can enforce those policies and make sure people really understand their responsibilities here. We can't do anything other than accept the recommendations of the inquiry. We're all saying that we do, and let me be absolutely clear. What we say in paragraph 1.7, we accept the recommendations of the inquiry in full. That's what the survivors want us to do, and I see that, Lord Provost, as a starting point in addressing this and getting us a better council for the future.
You've gone on mute, Councillor White.
It's told me on my screen, Lord Provost, that someone in the meeting muted me. Councillor McVeigh referred to the timeline here, and this being over a very long period. And I understand that. And things have changed and people have changed in the council. But the inquiry and the review that Ms Tanner is undertaking are linked. And some of the things we've seen here are about culture and about the way we choose to implement practice and policies. We need both if we're going to solve this for the future and get as far as we can to ensure that something like this never happens again. Thank you, Lord Provost.
Thank you, Councillor White. Councillor Cameron, again caught you just having a quick swig there.
I'm so sorry, I'm very croaky today, Lord Provost, I do apologise. What I'd like to say is this, first of all. On average, a woman or anyone who is subjected to domestic abuse, on average, is assaulted 35 times before he or she even tells someone else. So you can just imagine the harrowing experiences of the people who have come forward to disclose their experience, what hell they went through before they disclosed. And then for that disclosure to be dismissed, disrespected, nothing done about it is just frankly appalling. The toughest thing for any organisation, in my view, to change is its organisational culture. And for this culture to have pervaded probably our most important service, looking after children and people, you know, social care, all of that, reflects a very unhealthy culture, and it's something that we have to address and take extremely seriously. Not being believed, not being taken seriously. I've lost count in the number of policy reviews we've had in this council in this term alone. As others have said, it's the execution of the policies that matter. It's the holding of our staff and ourselves as elected members to the highest possible standards. We are elected to represent and act in the best interests of the people of Edinburgh. And collectively, we must do that. And for that to happen, I believe that all elected members should be in the loop and alerted to these sorts of practices as soon as possible. It's not just for senior councillors to know about. I think that I was reflecting, on a number of Ms Tanner's responses. And I've got to say this, I served for a time on the Personnel Appeals Subcommittee, and many a time I was surprised at the level of disciplinary action that was taken against staff for what I would consider not meriting the kind of misconduct or the category. When I think of the paperwork and the investigation and the time that have gone into disciplining staff, very often in lower levels of the organisation, and then I come to read this report, which is startling and shocking. Things have got to change fundamentally. Fundamentally, they've got to change. And as someone with lived experience of domestic abuse myself, I am very happy and all too willing to contribute in any way I can to whatever steps we decide to take today in terms of shaping that response. And Councillor Dickey is absolutely right, and we must pay tribute to her and her diligence and her doggedness to speak up when it's difficult to, and being able to, and not being believed, not being taken seriously when you're an elected member. That certainly reflects an organisation that is unhealthy in parts, and that has to change too. Thank you, Lord Provost.
Thank you, Councillor Cameron. Councillor Rose.
Thank you, Lord Provost. To use a metaphor from earlier on in this debate, the motion before us must not be a full stop. I agree with many of the points, all of the points that have just been made. by Leslie in relation to being believed. And I believe, in fact, I know there are survivors out there who have not been believed and who feel absolutely crushed by that and by the way they've been treated by the organisation here. And so I just want to give my thanks to those who have put their head above the parapet, who have stood up, and I support this motion as being the beginning, not the full stop.
Thank you, Councillor Rose. I'm not seeing any other contributions until Jim Campbell popped up. Jim.
Thank you, Lord Provost. As a new councillor and as somebody, I wish I had not had to deal with this clearly, and I'm very glad that this represents a start to, I hope, addressing some very serious failings in the council that go back a very, very long time. But as a new councillor, I think what I'd like to do is just pay tribute to some of the councillors that have been around a lot longer than I have, who have doggedly stuck at trying to expose this wrongdoing and earlier wrongdoing. At the last meeting, we also had a report about serious wrongdoing within the council. And I think there are a group of councillors who sometimes at some considerable loss to themselves have kept this council focused on some of these problems, and I think they deserve our gratitude. And I think today we should recognise that, and perhaps without their doggedness we wouldn't have got as far as we have. So I would like to record my thanks to those councillors that have stuck on this issue and have made it a focus for this council.
Thank you, Councillor Campbell. Councillor Munn.
Thank you, Lord Provost. I want to associate myself with everything that's been said so far, and the tone of the questioning in the earlier session. And I've, as somebody who Councillor White's referenced how long he's been on the council, I've been on and off the council over that same period, and he will know, as I do, and others who are present here today, that there have been other investigations in this council over another range of different matters that are concerning to us as elected members, and are concerning to the citizens of this city, and concerning to other employees of this council. And one of the things that has struck me when I read the report on Monday, the full report, and when I reflected on previous investigations into other aspects of this council, was that a lot of this was cultural. There was a culture in these sections of the council, and to read a report which referenced an old boys network, I find deeply troubling, and that we can be here in 2021 where we're only maybe just getting clear of that kind of culture. I welcome this report. I think it has shone much needed light on the way that kind of corrosive culture has damaged this council, damaged people's lives. And I want to commend the survivors and those who took part willingly in giving evidence for the part they've played in bringing this report forward. I hope that this report and the recommendations, as we move forward and implement them and develop new policy alongside the report that's to come on the culture of this council, will see this council in a far better place, and that elected members in the future do not have to deal with this kind of report again, because we are able to get things right for everyone, service users, employees, and the wider city. This is, I just go at this report, to me, when I read the full report, I found it quite harrowing, and it's the second time as a councillor on this council that I've had to read a restricted report that was harrowing, and I don't want any elected member to have to go through that again. And I certainly don't want employees or users of our services to go through some of the things that have occurred in the past, and I want them to be in the past. Thank you, Lord Provost.
Thank you, Councillor Munn. I have no other elected members wishing to make a contribution at this time. So just before we go to the paper, I'd just like to make a small contribution myself, in particular in relation to the recommendation of setting up an independent investigation unit. We've just heard that we've had previous investigations before in other areas. We heard from Suzanne Tanner that she was focused on one work area and didn't get a chance to look outside that. She also raised the concern about whether staff should be investigating each other, fellow employees, which I think was a very, very valid point. And we've also heard elected members talking about the fact that just implementing new procedures and policies might not actually change anything on the ground. I'm therefore very encouraged by the all-party amendment, and I have to say I think this is the first time in my almost 10 years on the council that we've had an all-party amendment on something as important as this, and I thank elected members for that. And it says in 1.8b that in delivering the inquiry recommendations, the Chief Executive give consideration to expanding the scope of the Special Investigations Unit, and I think that's a very welcomed addition in terms of the recommendation. But also I've been discussing this with education expert Neil McLennan, who's in a different part of the country looking at a different inquiry with children. And he's of the opinion that perhaps we should follow the Scottish National Health Service situation of having an independent national whistleblowing officer. And I would ask that the Chief Executive, when he's interpreting 1.8b, perhaps considers discussing with COSLA whether something could be set up on a national basis that would benefit all councils, because I don't believe that we as a council stand alone with this type of risk and behaviour. So that is my small contribution to the debate. I would now say we have no alternative position, so council minded to accept papers, both papers in relation to 3.1 and the all-party amendment accepting our recommendations. Are we agreed?
Agreed.
Agreed.
Excellent. Thank you very much. Thank you very much. Of course, such a short debate has now makes a fool of us moving back the deputations to 3 o'clock because we've now got a bit of a gap. So can I suggest, Gavin, that we just continue with the agenda and let's see if we can get